All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All have cause to plead. Draw near. Give attention. You shall be heard. God save this United States, great state of Florida, and this honorable court. Ladies and gentlemen, the Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. Today we're going to take up case number 22-122, which is the report and recommendations of the Workgroup on improved resolution of civil cases. Before we start, I just want to say the court really appreciates all the hard work that went into this, obviously an extraordinary amount of work from the work group, but also the commenters. It's obvious that a lot of thought and care and effort went in to thinking through these proposals and, really giving us the kind of feedback that we need in order to be able to, do the right thing for the state of Florida. Just for purposes of your planning, we're going to take two short breaks throughout this morning. The first one we'll take after we're finished hearing from Megan P. Kaluka. Then we'll take a break at the end of the commenter's presentation, Mr. Regensdorf, and then we'll come back and finish up with all the presentations from the workgroup members. So we're ready to proceed.
Good morning. May it please the court. I'm Robert Morris, chair of the work group on improved resolution of civil cases. My co-presenters this morning are Judge Jennifer Bailey, the administrative judge of the Civil Division of the 11th Judicial Circuit, Miami-Dade County, Judge Robert Lee, the administrative judge of the Broward County Court, and a very distinguished trial lawyer from Jacksonville, Tom Edwards. We will divide our time. We have an hour of time, as you know. I'll speak for 15 minutes. They will each speak for 15 minutes in rebuttal. I'm going to address the choke points in moving civil cases in our system and our rationale for making the recommendations we did. Now, I'm going to address the issue of resources and the challenges of elected trial court judges, some of which we aim to remedy by our recommendations. So a lot of what we have done has been focused on the fact that our judges are elected as opposed to federal judges, of course, who are appointed. Judge Bailey will address case management in general, the proposed case management rules in particular, and the pretrial coordination court. As the comments have focused on the motion practice, which is really the most difficult part of this whole piece, motion practice is really where all the problem is. Judge Lee is going to address in rebuttal the proposed motion practice rules, hearing availability, perhaps docket management a little bit, and the need for these proposed rules not just to be in circuit court but also to be in county court, because there's been a little sort of pushback on that issue. In rebuttal, Mr. Edwards will address discovery because he lives it, and that also is a very problematic area of the civil justice system. He's also going to talk about proportionality because that's been a big topic of conversation both in our meetings and in the comments. So that's a big issue, and he's going to address that. The oath of the Florida Bar includes a comment that all lawyers shall not delay anyone's cause for lucre or malice. Sadly, delay is very much a part of the civil practice in Florida and probably elsewhere. Delay is just part of the process. Our proposed rules and amendments are targeted so that we all honor this promise we make to the bar and to the people of Florida in doing what we do. We know for certain that deadlines move cases. That's very simple, but that's really the point. Deadlines move cases. People do things in the face of a hard deadline, and many times that's when cases settle in the face of a trial. So firm trial dates, discovery cutoff dates, dates for dispositive motions to be heard, These are critical to move these cases forward. And I really think lawyers will come to appreciate over time that the deadlines for the entire case are laid out early in the case management order. It'll facilitate better planning of their practices as well as their personal lives. And Judge Bailey is going to drill down on this much more deeply in her comments. We also know that motion practice clogs up the civil justice system, and hearing time is a precious commodity. Motions decided on papers without a hearing may break much of this logjam, but Judge Lee is going to talk about that in greater detail. The current discovery rules encourage delay, waste, and abuse. The proposed changes that we have are not just procedural, they're cultural. We need a culture change in the civil justice system. So we must change from a culture of not making discovery, for example, until a judge orders me to do so, to a culture of when in doubt, I better produce it or I'm going to get sanctioned.
Judge,
Mr. Edwards.
Judge, could I interrupt you for just
Sure.
1 second? And could you maybe recap for us what evidence the work group has that this structural problem you've identified is worse here in Florida than in other state courts?
I don't know that it is worse here in Florida than other state courts, and probably one of the reasons for that is that other state courts have moved faster than we have to address these problems. And a lot of the things that we have put in our report came from the innovations of other states. So I don't know that I have that data for you. Sorry, Justice. Mr. Edwards is going to talk about these discovery issues that I've mentioned. Judicial discretion. Why judicial discretion can be a blessing or a curse. And there's lots in the comments about how we seek to curtail judicial discretion. If judicial discretion is largely left unrestricted, granting a continuance or failing to oppose sanctions for a discovery abuse can look arbitrary and facilitate abuse and delay. In order to hang tough, an elected trial court judge needs the cover provided by the word shall when it comes to imposing sanctions for discovery violations or in granting a continuance only for extraordinary unforeseen circumstances. Popularly elected judges like to be popular. They need to be popular. They like to look good in a power poll. They like to get an award. Most importantly, they like to get reelected. Imposing sanctions, denying continuance in the face of, a lawyer or a group of lawyers that really wants it badly is not the best way to be popular. And at the end of the day, we're all human. And internally, it's easy to buckle to that. Dilatory discovery production is motion intensive and contributes heavily to clogged court dockets and a culture of delay. So soft trial dates, like I mentioned, which can cause large chunks of open time on a trial court's docket when a case is continued, is strangling the system. Every civil division, every judge has got a trial week or something. And we know 0.04% of civil cases actually get tried. So we're holding huge blocks of time for a highly unlikely event. And so continuing trials is just exacerbating that problem. Yes, sanctions are everywhere in our report. And we've not recommended this because we're autocratic, but because we recognize the growing culture of noncompliance in the absence of consequences for failing to follow the rules. Mandatory sanctions and the elimination of the elusive finding of willfulness, which is necessary to impose sanctions, force properly elected judges to deal with this issue head on. So if you get a discovery request and you object to the discovery request and your opponent has to file a motion to compel, if your opponent wins a motion to compel, you're going to be sanctioned. The court will have no choice. If you lose it, it's the reverse. So somebody will get sanctioned if that issue has to come before a court. That's harsh and concerning. And we know that sanctions cause lawyers problems with the bar, board certification, they're malpractice carriers, and we don't take this lightly. but those are very strong incentives to stop playing games and comply with the rules. If you're really worried about that, the best way to do it is to produce it. When in doubt, produce it.
Judge Morris, on the sanctions for lack of producing certain discovery, somebody's going to pay. Would that be true also in situations where it's truly a close call? I mean, there are some discovery disputes that are legit close. Is somebody going to pay in those instances as well? And that is the weak point of this issue, because there are close calls, but there aren't that many of them. But they're there. So somebody will pay. And I guess what I understand from the commenters, their bigger concern is being sanctioned. In other words, loser pays is not as problematic for them as being sanctioned. And that's a concern. And I guess, the only way that you can avoid being sanctioned is to, when in doubt, produce it, or, spend some time talking to your opposing counsel and meet and confers and try to cooperate in producing this stuff. But I can see scenarios in a close, legitimate call, somebody getting sanctioned. But courts are supposed to, the punishment should fit the crime, right? And if it's a close call and you're going to get sanctioned and the judge understands a close call, I would imagine that it's going to be, not a terrible punishment. But, that's where courts will have the opportunity to soften this. But this will definitely reduce discovery motions, because people aren't going to want to put themselves in that situation. And reducing discovery motions will free up calendars tremendously and move cases.
Judge, can I ask you a question?
Yes.
So obviously the work group, in response to its charge, and I think in response to trying to kind of, propose as much as you possibly could to kind of fix all these problems, you obviously took a very comprehensive approach. If you were going to prioritize the top one or two things, and I understand that some of this stuff is meant to kind of work together, but if the court wanted to take a more incremental approach, what do you think are the one or two things that are that would give us the most bang for our buck?
That's an excellent question, and we spent a lot of time on that ourselves, because phasing it in was attractive to the commenters, was attractive to a lot of people. And we had several meetings on this phase-in process, and frankly, it's like peeling an orange. Everything's so connected, it's very difficult to find a stopping place. Obviously, the easiest thing are the case management orders that have already been in place in the interim AO for COVID. That's clearly underway and an easy stopping place. But after that, it starts to become very difficult to separate motions from sanctions and things like that. And we, frankly, had a hard time and were unable to do that. So the clear, I think, demarcation would be the case management orders and that process and everything else. Now, I wish I could give you three, but I'm not. We had a real hard time with this because we wanted to do it. We just couldn't get there. Resources. Let's talk a bit about that. Resources have long been an issue and may be further strained in the short term if the imposition of these rules go forward, only because change takes adjustment. The absence of staff attorneys and magistrates in civil divisions is a serious problem. I mean, you can't deny that it is. It's a serious problem. And it needs to be given a hard look and maybe given a priority in the appropriations process. I'm not saying every circuit civil judge gets a staff attorney and everybody gets a magistrate, but maybe a couple of magistrates in a division and maybe more staff attorneys there, because that's really going to make things move, irrespective of our proposals. That's the problem now. I mean, I don't think it's going to, frankly, be any worse. But we passed on proportionality for resources. That's why we passed on it. Proportionality is hearing intensive. And so, because, there's lots of hearings about what is and what isn't proportional. That's what federal magistrates primarily do. They're spending time on discovery disputes and particularly proportionality. We also need to remember in the resource area, on January 1st of this year, because of the increase of county court jurisdiction to 50,000, 34% of current circuit civil cases will move from circuit to county. That opens up a whole lot of judge time. And that's a big addition to resources. On a smaller scale, it's taking the county court appeals from the circuit court, putting them in the DCAs, does the same thing. Some judge or judges in each circuit were handling these. They really aren't doing that anymore. They have more time to do something else. It's a much smaller issue than the one I just mentioned, but it's still there. And these things have a positive impact on freeing up judge time to do some of these things. On the other hand, assignment of cases to one of the three proposed case management track is currently being handled with technology in several circuits. And a lot of people envision that a judge is going to be looking at every file and deciding what track to put that case in. Technology does this, and we can borrow from the 11th and the 13th and the 20th, and use this resource to pass this around. So that's not a resource problem. Undeniably, these changes will be a major change in the civil justice system all at one time. And to be successful, there must be buy-in from both the bench and the bar, and the majority of them must believe that these changes are necessary in order to buy in. We have to embrace this paradigm shift as a unified legal community, if possible. To achieve this, we're going to need to have all sorts of educational programs that should really predate the implementation of this, if we go forward. To be sure, there's going to be glitches. This is perfect. It's no more perfect than we are. We're not perfect. We did the best we could with a very complex subject matter, and there'll need to be tweaks as we go along. We are profoundly grateful for all the commenters, all 68 of them. They took their time and their energy to do something that they did to do on their own. But unfortunately, much has been talked about the burdens on judges and lawyers, and very little has been talked about the burdens that the current system has on the people, and they need to be our focus. So we made it our best effort to do that, and I'm out of time. Thank you.
Good morning. May it please the court. My name is Ann Lee Gaylord Moe, and I'm a circuit judge in Tampa. I'm here on behalf of the 13th Circuit.
Could you adjust that microphone up a little bit? There you go. To barely hear you.
I normally remember to do that. Thank you for the reminder. So I have three topics. The first is that the 13th Circuit completely agrees with the work group that additional resources are absolutely essential for you to be able to continue to see the excellence that you can expect from the 13th Circuit. I'm sure that that's true for all circuits. There are specific areas that I'd like to cover if time permits on that. The second topic is the issue of eminent domain cases. The work group recommends that eminent domain cases be exempt from the proposed Rule 1.200 up through the entry of order of taking. These cases are really very unique. They should be exempt. All cases in Chapter 73 and Chapter 74 should be exempt the whole way through. The third topic is that case management works. We have seen it in the 13th Circuit. We are profoundly grateful for Justice Kennedy's leadership with the administrative order that required it. It would have been a very difficult thing to do if we hadn't been told that we had to do it. But what we have seen is that statistically there is no denying that it works. Having it automated makes it work better. And what we have done in the 13th Circuit with automation has resulted in, if you drill down into the numbers, and if my numbers are correct, then we essentially swung from, when the pandemic was hitting the hardest and the cases were beginning to snowball, we swung from being in the hole, having more than 700 extra cases in the hopper that had been pending for more than 6 months, and now we have 700 fewer cases today that have been pending more than 6 months. What that tells you is that cases are moving quickly. We have fewer cases in we track them from 0 to 30 days, 31 to 60, and so on and so forth, all the way up to 6 months. We have fewer across the board in every division. What I think that tells you, it's important to realize when you see those raw numbers. We had, sadly, one of our judges pass. He was terminally ill, and he passed in the middle of that time. We have judges who have had the opportunity to engage in different levels of how detailed their case management was, and those numbers still hold. That's the argument for automation of case management, is that no matter how engaged you are, it's happening. and it's going to happen, and it's going to be fair, and it's going to be consistent for the lawyers, which is what they need. They need to have a consistent understanding of what's expected of them, because it's not fair for them to walk into one circuit or one courtroom and have a completely different experience with regard to case management. Nor does that make sense for the people, because case management is so helpful to getting their issues resolved in a timely way.
So is it fair to say that when you read the work group's proposals that you were sympathetic to the aspect of requiring the front end triaging of the cases and getting a case management order in place?
In the sense that I think it's a good idea?
Right.
Absolutely, I was.
So what was the next, in terms of you reading it with your experience as a judge, what was the next most appealing thing about it in terms of something that you think would make a real difference in terms of improving the efficiency and fairness of our system?
In terms of the work group's proposals?
Yeah.
Well, there are two things. Number one, the elimination of the at-issue requirement is very significant, because that is, even with active case management, that is the most common reason why I can't set a case for trial, even when I'm using our system, is because it's not at issue. Number two is, I think that there is a real benefit to aspects of the motions rule for trial judges if we eliminate the idea that you must have a hearing in order to be afforded due process, and if we move to a system where if you are going to confer with your opponent before you file a motion, your opponent tells you that they oppose the relief that you're requesting, and then you file your motion, they should have to say in writing what was wrong with the relief that you were requesting. And if ultimately it would be more efficient for the judge to be able to rule on the papers, the judge should be able to rule on the papers, because that won't happen in every case. We're never going to be exactly like federal court, but we can be better than that.
Does it strike you as it seems like those two things could be addressed kind of more surgically than, and this isn't a criticism of the proposal, but am I wrong that those two things could be addressed in a kind of a less sort of comprehensive way than they have been?
We have tremendous respect for the efforts of the work group, and I know that they have said that they are concerned with separating them out, and I trust that they have looked at that in significant depth, and it's obvious that they have. But it seems like, for example, if you look at the Middle District of Florida in Local Rule 3.01, that's a motions rule in the Middle District. They lay out a process that's very similar to what I think Mr. Curry is going to share with you from the Rules Committee, where it's a conferral, motion, response, reply. That's it. They've done that without all the other mechanisms, and so it seems entirely possible that there was a way to do it. And I think Local Rule 3.01 in the Middle District of Florida works very well.
Thanks.
Thank you for your time.
And I know you're a little bit over, but if there was something on the technology front that you wanted specifically to tell us about.
Well, thank you. I think that on the technology front, what we need is technology that has the functionality of PACER. We need, particularly the motions rule, we need to be able to see that a motion's been filed. We need to be able to see how long it's been pending. We need to see that it's ripe now that a response has been filed. And ultimately, PACER also has, and by the way, in terms of the motions rule, the 60 days is I think, if we had the right functionality to work with it, it would be something that we could all do. But ultimately, that 60 days should run from when the motion becomes ripe for decision, because it's not ripe for decision until you've seen the response.
The 13th has some of the best homegrown technology in the state. Do you have that now, or is that something you desire to have?
We do not have the ability to track motions and see how long each one has been pending, and that is a serious concern that we have. It's probably the biggest reason why I'm here. The biggest concern that we have is that we lack the technological ability, particularly if we're required to self-report. What you can be confident of, and my colleagues in the 13th Circuit, is they aspire to do absolutely everything with excellence and the way that you tell us to do it. And if we need to self-report if we haven't ruled, that would be our intention, but we currently don't have the ability to know.
Does federal court?
Pardon?
Do federal courts have that?
Yes, they do. They get a weekly report. And I clerked for a federal judge that we went over every week what motions were pending, which ones had been pending. In their case, they look at for 6 months. With the Civil Justice Reform Act, and you are constantly doing triage, based on what's filed this week, what now is top priority to rule on. Thank you.
Thanks. Mr. Baggett.
Good morning, and may it please the court. My name is Fred Baggett. I'm a shareholder with the firm of Greenberg Traurig, and I'm here representing the Florida courts and comptrollers. The comments that the clerks have filed are really not directed towards the merits of the proposed changes, but the operational impacts that the clerks see will occur in their offices if adopted as proposed. I'll get to that in a minute, but first I'd like to just address some comments that relating to Judge Moe, what she's brought up. I think what has been done in the 13th Circuit and the 11th Circuit with regards to the integration of their court's case management system and the clerk's case maintenance system is admirable. And it shows that automation can be valuable to the process, relieving both the courts and the clerks of some level of duplicity of effort. We do not believe that there is a need for a standard single system throughout the state. There may well be a need for a standard uniform process throughout the state that is utilized by each of the clerks and the courts, doing what has been done similar to the 13th and the 11th Circuit and connected together. There are not 67 clerk systems in Florida, as many people have suggested in the past. There are, I think, 3 more than there are judicial viewer systems in the courts. All of these can be put together and worked as a single uniform process while still being individual systems. In 2002, California undertook to create a master single uniform system. 10 years later, and $500 million of cost, they pulled the plug when told it would be another $1.5 billion to complete. We're not suggesting that it would cost that, but it would cost a lot of millions of dollars for us to just attempt a single statewide system as opposed to the process. But we do find value in what has been accomplished in those 2 circuits, and we work with the court and the courts throughout the state and the clerks to develop a standardization. There is one requirement, though. It would not allow a chief judge to deviate from that system by administrative order, as has occurred in a number of other standardization efforts. Standardization means that, standard throughout the state. As to the clerk's comments themselves, and my red light is already blinking, if I could indulge you just to say that we view the proposed rule changes, almost each and every one, to create significant additional workload and technology increase in updates, which will create a funding issue that, as Judge Moe pointed out in the 13th Circuit's comments, the courts themselves are overloaded, clerks are overloaded, and underfunded even more. I will not dwell on this for the purpose of the court. We've had plenty of opportunities in the past to discuss this. But there will be a workload issue that we will have to compensate for somehow. Thank you.
Thank you.
Good morning. May it please the court. My name is Lance Curry. I'm here on behalf of the Civil Procedure Rules Committee. And I just want to thank the court for the opportunity to be here to speak to y'all. I'm going to start with a little bit of gloom and doom, but then I'm going to shift to some recommendations, because I do believe that there is an incremental path to case management to achieve the goals that I think we're all trying to achieve. We're all on the same team here and trying to improve the justice system. We just have different thoughts about how to go about it. But when this court adopted the federal summary judgment standard, it transplanted the federal rule 56, into our state court system. It did that in part because it brought with it the old soil, right? Those settled decisions that lawyers and judges and litigants could rely on to understand and grapple with that change. And what I would submit is that in the work group's proposals, there's very little settled soil. There's very little old soil in these work group proposals. And that should be a really huge concern for this court, because if you adopt this widespread swath of changes to our civil system, to 30-plus rules, it is going to create massive amounts of litigation for years to come. It's inevitable. If you do that many changes that fast, it's going to shake the system up mightily. And that may be, if we were all in agreement that doing this all-at-once approach would be worth it, you know, that these are growing pains that we would have to suffer through to really greatly improve our system, then it might be worth it. The problem here is that there are no assurances that it's going to be worth it. The work group itself says that the goals that it's seeking to achieve are really based on anecdote and conventional wisdom.
Could you address specific proposals rather than, I mean, I understand your point about not doing too much, but if you could focus on the case management order, the differential case management idea that's here. How does that fit into your conception? And do you think that that would be a train wreck? Because you're describing a train wreck. Do you think that adopting that in itself would cause a train wreck?
And I'm here on behalf of the committee.
I understand.
And I think the committee would say that they're very supportive of case management and even active case management, and supportive of what the court has already done in the pandemic in implementing, you know, certain initial steps, incremental steps towards case management. The committee is in favor of additional steps in case management. We recently approved a change to Rule 1.280 to require federal-type case management meetings of the parties and the filing of those joint reports. I think if we were to make a recommendation as a committee, it would be to look at changes to Rule 1. Go ahead and continue with the administrative order that's in place requiring case management orders. Perhaps adopt 1.280 changes to get the parties going, get the parties initiated in that early case discovery process, and then have the committee, maybe on an expedited basis, really look at what we can do to amend the case management rule and the at-issue rule so that it works all together with the system that we have going right now. The big problem right now that I think that we're facing is it's not worth gambling with our system, rolling the dice to see if all of these widespread changes will work, especially given where we are right now. We've just weathered the storm of the pandemic. As Justice Kennedy, as you mentioned at the annual meeting this summer, the pandemic-related backlog of cases in circuit and county civil divisions have been reduced by more than 60%. I mean, that's amazing. Our system is working, due in large part.
Well, what we heard from Judge Moe is that has happened because of the emergency case management measures that we've taken. And I think what the work group is focused on is how can we institutionalize that, because that's an emergency order. That's related to the pandemic. That can't go on forever. Now, we're dealing with the backlog from the pandemic, but what we're focused on here, and the work group is focused on in terms of case management, is trying to figure out how to institutionalize that, to make that part of our rule structure. But it's like we've had a dry run with the concept, and it has worked. I'm sure it hasn't worked perfectly. Okay, I'm sure we could hear about some problems that have existed with it, and so we want to learn from that experience. But it seems to me that having gone through that and being way into that, it makes sense to figure out how we could now institutionalize the benefits that we've seen that have flowed to the system and, ultimately flowed to the litigants. This is, what we're all here for. We're here for the litigants. The court, that's our responsibility. That's the people of Florida, the people that come to court. This is about trying to figure out how we can all, in the bench and bar, do the best possible for them. And I think that those case management orders have helped with that, and the point is how we institutionalize that. Does that make sense?
Absolutely, Your Honor. So the case management orders that are being utilized today obviously have to respect the at issue rule, right? So you can't just set a trial date out of the gate and then run your deadlines the way they do in federal court. And
well, I mean, the order has done that. It didn't necessarily have to, but that's the way it was structured.
Yeah. Well, the ones that I've seen have said that we will set a specified trial date at a later point in time when the case is at issue. I think that's something that should be given careful consideration as to how do we move away from this at issue rule that we've had for decades, right, that our system has kind of been centered around.
Well, I think the point of aggressive case management is that you got to get it to the point where it is at issue.
Yep.
And it can't just be discretionary with the lawyers as to when they're going to get around to it. And I'm not saying that happens with most people, but we know that there are cases that will languish. Sometimes it's on both sides. It's just not getting priority. Sometimes one side has a great interest in making it languish, and this is to avoid the sort of games that are played with the at issue rule.
No, and I agree. I think that's exactly why the at issue rule really needs to be critically evaluated and look at. I think if the incremental change is going to take place, the focus has got to be 1.200, the case management rule, trying to pull in some of what you've already done with your administrative order and looking at the at issue rule. That's the first step, right? And I know that the rules committees move slow and are inefficient, and we're looking at that. Not just our committee, all of the committees are studying ways to be more efficient in bringing proposals to the court. But sometimes a cautious approach is the best approach. Justice Cardoza once wrote, "Justice is not to be taken by storm. She is to be wooed by slow advances." And I would submit that the widespread changes are taking the civil justice system by storm. And what we need to do is take our time, allow what has already been done to work, and look at it in a cautious manner, change the case management rule, change the at issue rule, and then make iterative changes over time that help the system without taking a huge gamble to see what happens.
And so could you please focus on the details? I understand that the committee's preference is to amend Rule 1.280 rather than adopt the proposed 1.200, which obviously is more kind of along the lines of institutionalizing what we've been doing in the emergency AO. But if the court thinks that it makes sense to do the 1.200 approach, could you just kind of focus on the highlights of what you think are the most significant changes that would have to be made to the proposal to make it work?
Yeah, I'll do my best. So we did recommend, the slower, subtle change that is more party focused. I don't think you can make the changes to 1.200 that have been proposed without eliminating the at issue rule. It really does get the judge into the game right up front. And I think that is something that my committee overall would support. I guess looking at the very specific instances, it is one of those things where if the proposal was sent to our committee to focus just on that, and I think that we would have enjoyed having the ability to really focus on that step as opposed to everything happening at one time. If we had time to just focus on that step, I personally, on behalf of the committee, would think that we would really want to look at the federal practice and how they work with Federal Rule 16 intertwined with Federal Rule 26, because that's a system that works. And making sure that what we end up adopting into our case management proposal, into our case management order, and eliminating the at issue, as closely as possible tracks what the federal courts is doing. No, understanding that we can't just wholesale adopt the federal practice. I think a lot of what is proposed does that, but not everything. It definitely goes beyond some of those in requiring the judges to really jump into the game early and actively manage every single case. And of course, resource issues are there. Far more cases in our state court system than they've got in federal court, and far less resources to address them. So that is exactly what our committee would recommend, is that you give us that opportunity to take the work group's proposal, take the comments, all of the 70 plus comments that we've received, and focus on the case management rule and the at issue rule, and try to get something back to the court that is vetted, cautiously considered, and I think tracks better with what the federal practice is doing.
And how long would that take?
I think we could do it in 6 months.
Could you do it in 2 months?
On behalf of the committee, no, no. Again, I think it's that important. I think,
I would be shocked if it were 6.
Yeah, I know. A lot of people probably didn't like me saying that, but I go back to, look, our
that's
system.
kind of the problem. I mean, that's why they've had to. That's
Understand.
you know what I'm saying. So I'm sorry. Go ahead.
Well, the reality is this whole process started 2 years ago. Okay, it was 2 years ago that the administrative order establishing the work group. Is that right? It was 2 years ago. And so this has not been a rush, okay? And I think everybody here understands that there's still a way to go. Okay, we're not going to come out of here today with this all necessarily determined. But at some, it's just how many years is it going to have to take?
Well, and this all started before the pandemic. This was in 2019.
On the eve of the pandemic.
And the pandemic caught. I mean, the work group did a great service to this state by giving advice about that administrative order. The advice on case management that went into that administrative order, and it has worked. We are weathering the storm. We have come back strong as a civil justice system, and we need to be cautious now about next steps. We don't need to rush it in 2 months. Let's take 6 months. Let's take the time necessary to do it right so that we're not rolling the dice with our system.
Is there anything particular in this proposed case management 1.200 that the committee specifically disagrees with? Like anything that, top 3 things?
I apologize. I don't have my specific list of the things. My recollection is we had kind of a global comment that we would rather do the 1.280 change. But I think the process, if the at-issue rule is changed, that's laid out by the work group, is a good one. I mean, it's obvious that a lot of work and attention went into crafting their proposed 1.200. It's just that our committee would like a little more time to really focus our attention on that. I mean, what we did when we get the work group proposals, we have this group going this direction and this group going this direction and trying to address all of the rule changes at once. And so I'd rather have my full committee looking at this important issue and focused on it, even if for a short period of time. I do want to address the issue quickly of the limits on judicial discretion, because that is a really big concern that our committee has. In response to the comments that all the commenters made, the work group stated that limiting judicial discretion is necessary to ensure the speedy and inexpensive determination of every proceeding. And we just fundamentally disagree that case management requires restricting judicial discretion. If all we're shooting for is speed and efficiency, then they're probably right. That's probably the best way to go about it. But what the work group is missing here is that part of our legal justice system, and what I would submit is a critical part of our legal justice system, is getting the just decision.
Well, this is a very first principles kind of debate that I don't know how much this really advances the specific work we need to do, as Justice Grosshans tried to get you to do, being specific, right? Like every rule that exists is in some ways a constraint on decision. That's what a rule is. So a rule constrains discretion. It's not enough, I don't think, to arm wave about how, well, these rules will constrain judicial discretion. All rules do. The question is, what's the right balance? And so what I would like to hear from the committee, if you're able to do it, is to give me something specific about a particular restraint on judicial discretion that your committee finds unacceptable and why.
Sure. And Megan Peek-Luca, who's going to speak next, who's also on our committee but filed a separate comment, is going to address that very specifically, I believe. But I can tell you it's really the biggest examples are in the continuance rule and also in the sanctions, the idea of mandatory sanctions.
Let's talk about the continuance rule for a second. What if the first time a party seeks a continuance, the current rule prevails? But for some subsequent continuance, the new rule prevails. Would you have a problem with that?
Well, I think that's a better approach than having these written directives that say the judge can't do it at all. I do think that that's better. Again, my committee has not considered that, at least not as a whole, so I'm speaking more on behalf of myself here on that. But I think that the idea that there are going to be these mandates that say, sorry, Judge, I know that this happened, but it says right here in the rule, you cannot grant the continuance. That does not ensure a fair and just determination of the system. We have to be able to empower our trial judges. This is clearly a situation where let's try other case management tools before we go to this extreme of limiting judicial discretion. I feel like several of these proposals that limit the judicial discretion are written to address the misconduct of a few, like the unethical attorneys and the judges who can't control their docket or are too concerned about the election process, whatever it may be. But we shouldn't design a whole judicial system that ties people's hands, including the judiciary's hands, simply to try to fix the conduct of a few people. That's not the right way to write rules.
Well, I guess, counsel, that there's probably different ideas about how pervasive the problem is. And I mean, the way you're describing this, it's just a little problem, just a few people. I think other people that I've talked to before this case was pending, I want to add, have an idea that this is a much more pervasive thing, and that it's stuff that's going on across the board. Not every lawyer, by any means, not every judge is affected by in the same way, but in a lot of places, things are going on that really should not be going on and are not fair. And again, it is about fairness. The point you made about that, this is not just about a speed and disposition, okay? There has to be a focus on fairness, obviously. That is a starting point. But a lot of these dilatory tactics that take place and the abuses that take place are unfair to the people who are on the receiving end of those. So we're trying to figure out a way to do that that takes into account the sort of factors that that Judge Morris talked about, that, the trial judges, they've got to live with these people who are before them. And, I mean, my perspective on that is if our court has to be the bad guy enforcing some things that will give the trial judges the tools they need to deal with the things they need to deal with, then that's something we need to do. I mean, does that kind of, I mean, I understand that's not inconsistent with what you're saying, but I think that is part of the kind of the genesis of this whole enterprise.
Yeah, I understand completely. I think that we should, our committee, the court, we should absolutely be looking at ways to curb that sort of conduct. And if there's ways that we can do it that can come from the court that send that directive to the judges, that's fantastic. What I'm also saying is we shouldn't design the system to try to deal with those bad actors when we know there are a ton of people who are doing it right, right? I'm more concerned, and I think my committee is more concerned about hurting the people that are trying to do it right by trying to address these bad actors.
Well, I think I think our focus, at least I can speak for myself, is on the incentive structure, much more so than it is on individual bad actors, which of course the rules do have to have a system for dealing with individual bad actors. We don't quarrel that they are very likely outnumbered, but I think that skirts the real issue, which is what incentive structure do the rules create to bring clients' cases to speedy and just resolution, which is our focus. The incentive structure has to be on the side of the client, not on the side of the lawyer's interests to delay or tactical interests for lucre or malice, but on getting cases to speedy resolution. And I think as we review the changes, what I'm interested in hearing from you is what you have to propose as an alternative to what the work group has proposed in terms of structuring incentives that way.
Well, what I would submit is that we need to see, I think that case management changes, the Rule 26-like reports and disclosures that are required, those will change things. I think we have to make those changes, implement subtle case, maybe not subtle, case management changes that force lawyers to get things going right up front, to deal with the judge right up front, and then see how those work. Because I guarantee you they're going to have an impact across the board. They're going to curb some of this conduct that we're concerned about, and maybe that's enough. Maybe we come back and say, now do we need to do more stronger sanctions? Well, look at what the data is showing us. The courts are in a fantastic situation, and the anecdotal evidence is, man, it's made a world of difference. Let's try those first before we take judicial discretion away from our trial judges. I mean, the federal system is built around trusting our trial judges. They have tremendous discretion. I know they don't have the election dilemmas and that sort of thing, but I do believe, and I think my committee would submit, that focusing our attention on the case management aspects of the changes submitted by the work group are going to achieve a lot of the goals that we're all looking for today.
And while we still have you, could I ask you the committee's position, to the extent you know, on something like what Judge Moe suggested to deal with the motions issue, kind of a more getting at some of the things that the work group was worried about, but in a more surgical way?
Yeah, so just we actually submitted an alternative motions proposal that instead of the judge being active right when the motion is filed, it operates more like some of the business courts are doing. The briefing is done by the parties without the judge's involvement, and then something is filed that the judge can look for that says, you know, we need a decision, and that triggers the court's involvement, the trial court's involvement, instead of having the judge jump in and determine at the outset whether or not there needs to be a hearing. So that's really the impetus of what we believe would be proper under a revised motions and hearing rule, is let the briefing process run with time limits, then get the judge involved and let the judge decide whether they need to have an oral argument on the motion.
Okay, thanks. And we do really appreciate all the work that the committee did. I know that there was obviously a lot of moving parts, and I'm sure there were tons of people who had to kind of quickly drop other things that they were doing to come up with these comments, so we appreciate it.
Thank you, Your Honor. Exciting times, that's for sure.
Sorry, lots of interest to be represented. May it please the court, my name is Megan Peek-Luca, and the Normandy invasion was less complicated than planning who says what when, so I am here on behalf of multiple different interests. There will be no smooth continuity and transition. I apologize in advance. I'm going to start with the continuance rule. There are actually two different rules that have continuance provisions. I'm going to start at 1.460A. I will mention in my comments, I believe that 1.460A is redundant of 1.200, I think it is F2, and I believe that smart lawyers will manipulate those rules. They are substantively similar. One requires your client to sign off on a motion, one does not. A savvy lawyer will use that to their advantage. So if there is going to be a requirement that a client sign off on a motion that requires a hearing of more than 30 minutes, put it in one rule pick one, just one, I would propose that it would be an F2 and you would eliminate subsection A of 1.460. More substantively, subsection B. Justice Coriel, to your point, I proposed in my comment that it should say that motions to continue trial are disfavored and should rarely be granted. Once it is set for trial, no continuance may be granted except for good cause shown. And Justice Kennedy, to your point, I live in Tampa. My firm is based in Orlando. Hillsborough and Orange counties are two of the biggest and busiest counties in the state. And I can tell you that in Orange County, our chief judge is not to be trifled with. And she has given all of her judges marching orders that say the Supreme Court wants us to get cases to trial faster. So you will not be granting continuances unless the parties are giving you a darn good reason. And if you're a litigant in Orange County, you know that. You're not holding it against the judge, you're kind of holding it against the chief judge. But she has made that clear. These orders are not even these rules are not even in place yet. There is more than one way to skin a cat, and you don't have to do it by taking away discretion
But counsel, the reality is that we have all our chief judges are wonderful. Okay, I'll stipulate to that at the outset.
Yes.
But they have different approaches, and they're all elected. You know, we don't appoint the chief judges; they are elected, and the dynamics in different circuits are just different. And some people, some judges say, "Well, you say what you want to. I don't care." That happens, and so the idea that is all that because we're going to have because it's possible to have a chief judge that will push and get the right results, that means we don't need to do things institutionally. I'm skeptical about that because I've spent a lot of time dealing with the different situations in different circuits, and I've seen, and again, I'm not, like I said, I love all the chief judges, but they're just, the reality of it is that you aren't going to have somebody like Judge Munyon everywhere.
Well, Your Honor, I would argue that this court does have the ability to lean on the chief judges and to say, this is how you should be doing it. This is how you should be directing your judges.
Well, the way we lean on them is through our rules.
Well, Your Honor, my concern, and I know that I think there were over 1,100 lawyers who signed my comment, so I know that I'm not alone, is that when you draft the rules so that it says that a continuance may be granted only for extraordinary unforeseen circumstances involving the personal health of counsel or a party, court emergencies, or other dire circumstances that provide extraordinary cause, that if you...
Well, again, counsel, don't understand what I said to be a necessary endorsement of every aspect of the proposal, okay?
Okay.
But my point was, help us figure out how we get the rules to accomplish these things to the maximum extent that it's reasonable to do so, rather than rely on some personality who is a particularly forceful person, because we can't do that. That's not possible.
Well, I do believe that you do need some sort of language that says that they should rarely be granted and that they should be granted for good cause shown. I think that you do need to say that it should be limited. You have to do it within 6 months. I think you do need to say that there should be a limit absent, at that point, extraordinary unforeseen circumstances on the number of continuances that you can get. I think you accomplish the goals in those ways and that it's less draconian. I would also note that the work group did amend the proposed continuance rule to say that if the dilatory conduct of another party is what causes the need for a continuance, then the court will grant a continuance. That is in B1. B5 says that no motion will be granted on any of the following grounds. Number one, failure to complete discovery. The A number one dilatory conduct is failure to complete discovery. The other side drags their heels so you can't get what you need. If B1 says that the court will grant a continuance because of dilatory discovery to conduct, and B5 says the court cannot grant a continuance because of dilatory discovery conduct, I will be back in front of you in 2 years arguing that those conflict. The same thing goes for outstanding dispositive motions. If they drag their heels and you can't get your motion for summary judgment heard, the two conflict. I can go on, but I don't have a lot of time. My point to you is that subsection B5 is unnecessary. I don't think that it is a good idea to include a list of reasons why you cannot grant an extension. I think that you will run into the rule of unintended consequences when you do that.
Ms. Lucas, it's obvious to me you spent a lot of time thinking about these issues. I found your comments particularly helpful as comments filed by others. Let me ask you to address a specific topic that somebody raised, and that is, what about the cases that are obviously behind? There's a certain category of cases that are delinquent, and if we were able to identify them and say, okay, these are past 120 days past due, what can we do about those? What case management tools, what rules exist or could be perhaps changed or some other mechanism implemented to address the cases that are seriously behind? Did you think about that issue, or do any of these rules address that or somehow deal with those cases?
Well, Your Honor, in the Uniform Case Management Plan, and I live in Hillsborough County, so I have the benefit of being there too. If your case existed prior to the implementation of the case management rule, you were required to take your deadlines and fit them into the Uniform Case Management Rule. So those cases should already be incorporated into that, and you should already have deadlines driving you towards trial.
But what if you're behind the deadlines? I mean,
if you aren't,
people blow past deadlines, believe it or not. You probably don't in your practice. It happens. Sometimes our orders get ignored. What happens to those cases that are passed? The judge is not looking at them, other people not looking at them. What can be done to address the cases that are delinquent?
well, Your Honor, in that instance, I think Justice Kennedy has a point, which is at the end of all of your discovery deadlines, which you might blow past, your motions in limine, your dispositives, your Dahlberts, your whatevers, you have a trial deadline. You got a date that you're supposed to be going. And if you go in front of the judge and say, Your Honor, I'm not ready, and the judge looks at you and says, well, why not? And you say, well, I've been busy with other cases. The judge, in that point, has the discretion to say, I'm sorry, that's not good cause. I'm not granting you a continuance. Y'all either need to go out in the hall and settle this, or you need to call your malpractice carrier.
What triggers that, though? What triggers the judge looking at that?
Well, I mean, Your Honor, nobody, I would hazard a guess, nobody blows past their trial date. And I think that in a lot of instances, that's when it does come to the judge's attention, because the parties stand in front of the judge 2 weeks, maybe a month, before their trial date and say, Your Honor, we're not ready. So
the key is getting the trial date set earlier, and that date is on everyone's calendar, and nobody's blowing past that one.
Exactly, Your Honor. And in Hillsborough County, you file your complaint, and within 2 hours, you have an order that lays out all of your dates for the rest of your case. You've got it before your complaint is even served. And do the parties sometimes have to go back to the judges and say, you know, these dates aren't realistic with the needs of our case? Sure, but you know what they are, and you know what you're working with, and you can plan off of that.
Okay, do these proposed rules accomplish that, the setting of a trial date?
Do these proposed rules? No, Your Honor, you need the technology that Judge Moe is talking about. Well, let me rephrase that. 1.200 is going to require you to sit down and have a case management conference with your opposing counsel, and it is going to require the judge to give you a trial date. So yes, I misspoke. It is required to do that.
So it requires the trial judges to set one?
Yes, Your Honor. The parties will meet, they will propose a date, and then the judge will enter an order, perhaps adopting the date that they proposed, perhaps setting a different one. But yes, the 1.200 will give you that trial date.
But so the lawyers actually have more input on the front end under the work group's proposal than they do under the emergency order process.
Under the way that Hillsborough County works, yes, the lawyers under 1.200 have more input, but it also takes more time.
I've been uncharacteristically quiet so far. I sat as you know, I was a trial judge for 13 years, and I sat in the civil division for 6 years in Palm Beach County. And I found I never had a problem with the continuance aspect of it. We scheduled the case for trial, mostly specially set it, but we would go to trial, something would happen. The problem that I found was in the front end of it, and where I would schedule a case for trial, okay, a year from now, specially set. That morning we pick a jury, and that morning one side or the other would unload like 5 new experts on the other side. And of course, then we have to deal with Binger versus pest control, and that would take another day or so, and trying to figure out whether I should exclude the witnesses or whether there's prejudice and that kind of thing. What I found was that the trial order setting deadlines for things to be done throughout the entire discovery process, those deadlines were not adhered to early on in the process, and it wasn't being, it was never brought up to my attention until right before. What happens is right before trial, lawyers really get intense with their cases, and they're looking at the file and they're finding out that this wasn't done, that wasn't done, and that kind of thing, and then they come in at the last minute with that. What I would think that would work in the front end is having a trial management conference like you suggest, and having a trial order that specifically sets forth deadlines for discovery to be completed, for witnesses to be exchanged, and so on. And if anybody files an additional witness list later on past the deadlines, you're going to have to come before me automatically, the trial judge that is, and tell me why should I allow you to call these 3 new witnesses, and deal with that in the front end. And when the case, many cases, I'm not going to say all, many cases are personal injury cases in the civil division. Plaintiff's lawyer on one side, guarantee you they protect that trial date with their life. I mean, you're not going to grant a continuance without them screaming at you. So there has to be a real good reason for that. People want to go to trial because nothing happens in that case until you have that one deadline date that where you know you're going to have to fish or cut bait.
And Your Honor, 1.200 does require that. It requires, there is an exhaustive list. The work group has a lot of sitting trial judges on it, and it sounds like they roundtabled the heck out of that because there is an exhaustive list of all of the deadlines that you have to come up with. And I completely agree with the work group's inclusion of a provision that says that lack of preparation is not grounds to continue the case. I primarily do plaintiff's work. It's the defense lawyers who come in at the last second and ask for the continuances. You're right. The plaintiff's lawyers guard those with their life. I completely agree with this. And I agree with you that the deadlines should be enforced. And I also strongly believe the work group has said it, they said it on the front end and they said it in their response to the comments, that education is an enormous component of this. I would argue that it's an enormous component for the lawyers and for the judges. They need to be educated. Lawyers need to be educated that this is the expectation. Like Judge Morris said, it's a culture change. Gone are the days when you can ignore the deadlines. Or I have teenage daughters. I tell them, these are the rules. Ignore them at your peril. There will be consequences when you ignore them, and they will be enforced. And so I believe, trying to circle back, and I'm sorry the red light's blinking and I'm barely even touched.
I have 3 questions for you. So as amended by the work group in response to all the comments, do you have any specific problems with 1.200?
Oh, Your Honor, I was not prepared to tell you all of my...
So you still do?
Yes, I do.
Could you give us the highlight?
I'll give you one, and it's actually the next point that I was going to make.
Go ahead.
And that's 1.200F5. This rule says that if your case does not go to trial on the date that it was scheduled to go to trial, in the original version, the work group said that the case must be reset to the next immediately available trial period. And my comment said, what does that mean? Does that mean that if...
And they took out the immediately, though, didn't they?
They did, and that fixed nothing. I still don't know what that means.
It depends on what available means.
Well, exactly. If the next docket is next month and there are 5 cases in line, does that mean that you butt everybody and you become number 1? Does it mean that you're at the end of the line and you're number 6, and now when you don't go on that docket, you continue to roll into perpetuity until your case is number 1?
Okay, what's the, and I don't mean to be rude, but what's the next, anything else with 1.200? Just because it seems like this is the thing that we have to get right. I mean, it seems like this is at least sort of the building block for everything else.
Your Honor, hold on one second. I have my 140-page comment in front of me. There are some housekeeping things lining up the wording so that extraordinary unforeseen circumstances make those line up. This rule, I think, is actually extraordinarily important. If you might indulge me for just a second so I can finish that point. If you are going to, 1.200 is designed to create uniformity. I think that was the work group's goal. The work group's comment in response to my concern about what does this mean said that the rule is not intended to preclude the possibility of local administrative orders and circuit or county-wide rollover practices. My concern there is that if you practice in multiple counties, which almost all of us do, and they have different rules, there is a provision in 1.200 that says that when you come to a case management conference, you shall come with your calendar and you shall be prepared to pick what the dates are going to be if the ones that have been chosen don't work out. But if you're rolling in perpetuity for a trial, you can't give any meaningful information because you don't know when you're going to go. And it also creates a problem because under 2.250, now when you've got cases where a judge or a lawyer says, I need to be in 2 courts at once, or I'm on 2 dockets at once, the judges are supposed to pick up the phone, call each other, and work it out. They're going to be doing that unnecessarily. I think that for the sanity of trial lawyers who want to be able to attend their kids' graduations and go on vacations, there needs to be uniformity in what the rollover process means. I would suggest that it is that if your case doesn't go on the date that it was meant to go, that the lawyers and the court shall sit down with their calendars and they will pick a date certain that is within 6 months. Something to that effect, so that you have something concrete, so that it is meaningful when you're planning other cases. You can plan your vacations. And quite honestly, if you're rolling into perpetuity, every time you're on a docket, you have to tell your expert, hey, we're up, I need you to be ready to go. And the expert isn't going to take any clients or patients or whatever that day.
It is particularly difficult for trial lawyers to try cases throughout the entire state. Some dockets are 6 weeks long.
Exactly.
And you're writing a 6-week docket, and you have doctors you have to call, experts you have to call, and you have no idea when you're going to get that call from the judge. And then you may have, if you down in South Florida, where I'm from, for example, if you practice in Palm Beach County, you're also practicing in Broward County and in Dade County, and vice versa. And you're writing all these different dockets that judges have, and one may be a 5-week docket, a 3-week docket, a 10-week docket, and you don't know when you're going to get that 1-hour call. It gives you 1 hour to show up to go to trial, and all those things are very difficult to assess, and especially setting cases, which I tried to do as often as I possibly could, is the answer to anything. The problem that I have with those is, as I mentioned, you have a year to get ready for trial, and in the morning of trial, they're exchanging witnesses lists. Then I have to do all these other tests and things, balancing tests. That's why I have my concern, and that's why I thought that perhaps the trial order up front, having some kind of requirement that if you're going to amend with a witness list at any time, you got to come before me first. And I'll tell you whether you can do it or not ahead of time. But that's my concern is, having been a trial lawyer, is this long dockets, and you have 1 hour call. I recall being a 1 hour call in 4 different counties. I have 4 boxes ready to go, praying that my witnesses will be available when the judge in Fort Myers called me for trial. It's very difficult on the lawyers. I understand we're here for the people of Florida, but the people who represent the people of Florida are the ones that have to deal with these dockets and making sure the witnesses are available. So I want to put in a plug for the lawyers as well.
Thank you. We appreciate that.
Okay, anything on 1.200?
Your
Any
Honor,
other highlights?
I'm sorry I wasn't prepared. I'm skimming. H7, as a practical matter, this requires the court, the parties to provide the court with a transcript of a hearing when they can't agree on a proposed order, and it requires it within 7 days. As a practical matter, transcripts are really freaking expensive, and when you have to rush order them, the difference can be $500.
Was that not changed in the?
To 12.
That was changed. Was that not changed by the work group in their revised proposal?
To 12.
Thank you.
Yeah, okay.
Yeah, part of the problem here is we've got the different versions.
Okay, so Justice Muniz, I think that that is the highlights of my, hold on, skimming again. Yes, those are the highlights for 1.200.
Okay, so my second question is, A4 seems like it's proportionality just by another name. What's the, and I know that other people are going to address that, but while we have you, I just wanted to quickly get your view on why not just go all the way and put proportionality in the discovery rule?
Hold on one second.
That's the relative to language.
Oh, okay. So, Your Honor,
Yeah.
I stand in solidarity with the work group that proportionality is much more involved than, like, in implementing the federal proportionality rule, because I do litigate in federal court, is much more involved, and it is something that does take up a lot more time. And it is also a strategic tool that I do not think that our state court system is, given all of the other issues and all of the other changes that we are examining at this point, I do not think our state system is prepared to address that. I think that all judges already look at what is being requested, and as a matter of common sense, they often say, you know, counsel, you're asking for medical records that are 30 years old. No, this is a car crash. You don't need that.
Okay, all right. My final question is, obviously your comments were hugely helpful. They were very extensive, but it's mainly reactive. I'm just curious, if you were in our situation, knowing the problems that we're trying to solve and knowing what's in front of us, and you were 100% in control of this whole thing, what would you do? What would your priorities be?
I would probably drink heavily. And then I think that 1.200 is enormously important. Like I said, I live in Hillsborough County, and I think that they have really, to say they've cleaned up their act makes it sound like it was dirty before, but I mean, it is a process there. And I think that having deadlines and enforcing them, and I believe that you do that, again, through education. I think you set a student up for failure when you give them the test and then you teach them the material. I think that whatever you decide to implement, whether you do it in a phased position or whether you do it all at once, you need to have good educators out there wallpapering every area possible so that lawyers and judges have an opportunity to know what's coming and to understand it. And again, if they choose not to take those classes, they do so at their own peril, but they will have been given multiple opportunities.
You can have 2 minutes to sum up.
Well, Your Honor, if I could please address Rule 1.160, because I do think that that is an important rule. I drew the short straw on this one because when I prepared a presentation for the lawyers to try to educate them, and at your podiums, I think you each have one of these. When I went to go try to teach the material, I could not understand Rule 1.160. I had to make a flow chart. And if you have to make a flow chart in order to understand how to file a motion and what happens next, it's too complicated. I sat down with the FJA, Bard Rockenbach and I took a laboring oar at trying to draft our own rule. I drafted by committee, didn't love that. I drafted my own. And then I turned around and I took it to the Civil Rules Committee, and Paul Regensdorf and Cosme Caballero and I attempted to draft one. There are 3 of them. None of them are perfect, but all 3 of them are far less complicated than what is in Rule 1.160. And I'll give you a concrete example. 1.160 requires you to file a motion, and under 1.161, within 7 days, you have to schedule the hearing. 1.161 has its own complications. I don't like that one either. 7 days, you've scheduled your hearing. Within 5 days of you scheduling your hearing, the judge has to decide whether he or she is going to hold that hearing. And the judge has to issue an order saying whether they're going to hold that hearing. Well, briefing hasn't been completed yet. If I'm the judge, how do I decide whether I want a hearing if I haven't seen the briefing yet? And there is no system for the judge. So the work group heard my comment and they said, okay, now the judge can rule about whether they're going to give you a hearing within 7 days of either you setting it or briefing being completed. But as Judge Moe noted, the trial judge has no way of knowing when briefing is completed, not to mention the fact that the work group's 1.160 doesn't require a response. I would argue that you should require a response, and if you're the non-moving party and you don't file one, then the motion can be granted by default because you obviously don't care. I would also argue that under the work group's 1.160, you can see that when the judge looks at the motion, they can require further briefing, they can rule on it without further briefing, or they can set a hearing. If you're going to file a motion, you need to ask for your relief, and if you've got a memo of law, you need to incorporate it. Put your best foot forward at the outset. Don't do this fancy dance where you file something bare bones and then you show up at the hearing and you bring all your case law with you. Come loaded for bear when you file it. That way, the other side knows what they're responding to. They have to file a response, and now when the judge looks at it, they know what they're dealing with. I would also argue that in all three proposed versions, the onus is on the moving party. So once briefing is complete, the moving party has to file a request for decision that notifies chambers that a motion to, expand the discovery cutoff was filed on X date. The response was filed on this date. I have waived a reply, or I filed a reply on this date. The hearing has been set for this date. And at that point, the judge can either look at the papers and rule before the hearing. They don't have to issue an order. You eliminate that, it's an unnecessary step. It just takes up more of the judge's time. The judge either, as in federal court, you rule before the hearing, or you go ahead and you have the hearing. Put more onus on the parties, not the judges. And I would also, on behalf of JAs everywhere, because I spoke to a few of them, we are going to have to come up with some technological system for how they get the alerts, because right now a lot of what Rule 1.160 requires is a notification via 2.516, which is email service. I had one JA show me what her email inbox looks like, and I would need medication if I had to look at that every day. It's insane, the number of emails that she gets. So we need some sort of technological system, like Judge Moe was saying, a tickler, somehow a box that you can check when you do the request for hearing so that the court gets the alert. Also, timing. The current rule requires judges to rule. If they decide that they don't want a hearing, they have to rule within 10 days. I understand the motivation behind that, but if you're a judge who's got a 6-week docket, when are you going to get those 10 days to file the response? You have no control over when the 10 days starts. If you look at it and you say, well, this is a straightforward, it's clearly a legal issue, there's no facts involved, I don't want or need a hearing, but it's complicated and I want to get it right, 10 days isn't going to be enough. A one-size-fits-all approach with that number, I believe, is not going to be effective. Final point on that rule, it could be interpreted, 1.160 as written, to do away with, in Orange we call it short matters, some call it uniform motion calendar, I think in Miami they call it cattle call, where you show up and you've got 5 minutes and it's a menial motion. It only needs 5 minutes. But under 1.160 as drafted, you have to set a hearing and the judge is going to decide whether you get one or not, and 1.161 doesn't have any protection so that judges can continue to have short matters. Those short matters in the counties that I primarily practice in are outrageously efficient. Stuff gets done, and there has to be a protection for that. And that dovetails nicely into what the Palm Beach County Bar Association has asked me to relay, which is a concern for young lawyers. when you're a young lawyer in practice, generally the first exposure you get to being in front of a judge is on a menial matter, something that if you lose it, it's not that huge of a deal. And when young lawyers go into courtrooms, that's how they learn decorum. It's how they hopefully learn to behave. It's how they hopefully observe a judge disciplining a lawyer who doesn't know how to behave. And if we aren't going to protect uniform motion calendar, cattle call, whatever you call it, and we aren't going to have opportunities for these brief hearings on easy motions, then we're going to have a generation of lawyers coming behind us where their first exposure to a hearing is going to be on a motion for summary judgment or a Daubert or some big motion. And I think the Palm Beach County Bar Association wants to convey that we can't lose sight of the need to ensure that our young lawyers are learning.
Let me, about that, counsel, I don't want to extend this much, but to the extent that a motion can be resolved just in a very short period of time, why couldn't that just be resolved on the papers?
Your Honor, I think that there are...
and I understand you get this other issue about the young lawyers, but in terms of the working of the system.
I'm not arguing that motions shouldn't be resolved on the papers. I'm an appellate lawyer. It's good for business. I think that there are plenty of motions. I know in Hillsborough, I talked to several judges who said, I would love it if I could just do motions to dismiss on the papers. I don't disagree with the concepts of 1.160. My proposed order or my proposed motion rule, all three of them allow for ruling on the papers. I think that there are circumstances, though, where judges might say, honestly, it's going to take me more time to draft the order than it is to just let these folks come in on short matters. I can rule immediately. I can ask them for a proposed order. And so my position on 1.160 and 1.161 is that as proposed by the work group, I think it is far too complicated. It creates too many unnecessary steps. It is not economical. I think that we can do better. I think that the three versions that you have in front of you from the FJA, myself, and the civil rules are close, but my dad says close only counts in horseshoes and hand grenades. This is the workhorse of our civil rules system. It can't be close. It needs to be darn near perfect. And I think that we have to go back to the drawing board on 1.160 and 1.161. And Justice Muniz, I think those, along with 1.200, are critically important. And I would also argue that the at-issue rule, if I had to cherry pick one out of the 30 while my brain is spinning madly, I love what the work group did to that rule. It needs to go. It is an affront to the efficient administration of justice. And then finally, the ADR section, the Alternative Dispute Resolution section of the Florida Bar, asked me to relay what I believe is a very practical point, 10.420. The work group would like for there to be a situation where in county court, when you've got 100 people assembled and you want to dismiss them to do mediation, they could wheel in a screen, for example, hit play, and a recorded message would give them the mediator's introductory statement that says, it's a consensual process and I'm neutral and everything you say is confidential. The problem that the ADR section has is that as drafted, 10.420A says that upon the commencement of the mediation session, the mediator has to give that. And then the work group has the amendment that says it can be given to a group. The ADR section is concerned that if it's given to the group, as the rule is currently written, when the mediators go into the individual rooms, they're going to have to re-give it because the rule says upon the commencement of the mediation. I think that if you just delete that clause so that the rule says a mediator shall describe the mediation process, then you remedy that situation. I make that proposal only after listening to their concerns. That is what would seem to make sense to me.
Quickly, if the case is subject to arbitration, do they still have to comply with all the rules and coming up with the conference and the proposed case management order?
Your Honor, it's my understanding that when a case is referred to arbitration, that it has now moved out of, for example, Miami-Dade County's circuit court system, and you've moved into arbitration, and the arbitrator can set their own deadlines.
Right. So, but if a party identifies right quickly, as they should, that this is subject to arbitration and they shouldn't be in court, and they file a motion to arbitrate, or there's one's going to be filed, are they exempt from participating in the case management process?
Your Honor, I believe that under the Rule 1.200, and somebody at this table could probably tell you off the top of their head, 1.200 is triggered upon the filing of the complaint. So I believe that you are going to have to engage in this process, and that if you are a defendant and you believe that the case should be in arbitration and the plaintiff has improperly filed it in circuit court, then perhaps it would be a good amendment to include that you are required to file that motion immediately.
That seems problematic to me, but I'll discuss that with Judge Bailey whenever she comes in.
But, maybe there's a provision that says that if you believe that arbitration is necessary, then you're required to file the motion immediately, and 1.200 is stayed pending resolution, and judges shall resolve that motion on an expedited basis or something to that effect.
Thank you.
Cool. Do you want to wrap up?
I've made a fine mess, and my brain is sort of pudding. Give me one moment. I just want to make sure that the people who asked me to speak on their behalf, that I said their piece for all of them. So, I think I covered the waterfront. I guess my ending is that I believe that the work group moved mountains, and that their work is valuable, and that it is important, and that at the end of the day, it is going to benefit the civil justice system. I think the bulk of their proposals are good, and I worry that if they're implemented all at once, that without proper education and proper time for people to adjust themselves, particularly solo practitioners, I heard from a lot of them that this would be an enormous shift for them, that they would need to consider whether they need to join practice with other people and how they're going to staff it and things of that nature. I think that rolling it out all at once is something that concerns me. I know that the work group would rather see it happen all at once, but I would also echo Justice Moe's comments that technology, we are going to need so much more in terms of technology if we are going to do this. And I thank the court for your time. I thank you for your consideration, and I particularly thank you for giving the commenters more time. We are very grateful.
Thank you. We're going to take a 10-minute recess.
All right. Supreme Court of Florida is now in session. Please have it.
Next up is Mr. Schenk from the Florida Attorney General's office.
May it please the court, my name is Robert Schenk for the Attorney General. The Attorney General largely agrees with the proposed changes by the work group as a means to increase judicial involvement in case management and to streamline litigation in Florida. We simply have three small changes to suggest to the rules. Two deal with timing for state defendants, and the third, where I'll spend the bulk of my time, deals with proportionality and adding an explicit requirement to the scope of discovery standard. As I mentioned, the first two suggested changes deal with timing for meet and confer conferences and the initial discovery disclosures. We've explained those rules impact in our comment, and The long and short of it is state defendants get additional time. The existing rules recognize that state defendants often need more time to respond to complaints. For example, state defendants often have to retain counsel and process complaints internally. So we've asked the court to put us in parity with private defendants with respect to our time to prepare for meet and confer conferences and with our ability to make initial discovery disclosures. So we've asked for those deadlines to be 10 days for the meet and confers after a response to the complaint is due, and 25 days for the response to the for initial discovery disclosures after the response to the complaint is due. Our third change is a proposal to add an explicit requirement of proportionality to the scope of discovery standard. In our system of civil justice, proportionality is a very important guardrail to protect against litigation where the burdens outweigh the benefits to the party and to our society as a whole. We think that including this requirement explicitly would align Florida practice with federal practice, which we see as a good thing. It would help streamline cases and also nip discovery disputes in the bud before they get out of hand. On this point, we believe the working group, the commenters, and the Attorney General are actually in remarkable agreement that some form of proportionality is a common sense requirement in our system. To the extent we disagree, I think that the working group believes that this type of practice is already done through the undue burden standard for protective orders. We simply don't think that this is remarkably clear to us. We think that a very simple way to ensure that clarity to the parties and to the court and so that they can prepare is just to make that recommendation explicit, put it in the standard for the scope of discovery, and so we would ask that you add the words proportional to the needs of the case instead of reasonably calculated to lead to the admission of discoverable evidence. And for all these reasons, we would ask the court to adopt these changes. I'm free to answer any questions, or else I'll cede the rest of my time. Thank you.
Thank you. Mr. Landy?
May it please the court. My name is Russell Landy, and I'm here on behalf of the nearly 6,000 members of the business law section of the Florida Bar who litigate cases regarding business matters throughout the state. We are very thankful for the time to speak with the court today, as well as for the work group's efforts and their openness to changes based upon our comment and other people's comments. I'm here to address 2 points, which I'm actually going to take reverse based upon the Chief Judge's questions. I'm going to start with a specific comment on 1.200, and that is regarding the case track assignments. The section agrees with the 3-track system of complex, streamlined, and general cases. The concern is that bench trials there's a presumption in the rule that bench trials are of a streamlined nature. And we submit it doesn't meet the criteria for those types of cases. Bench trials are often cases that require high levels of judicial intervention or time. Some of them are for cases where there is no right to a jury trial. Some of these cases are shareholder derivative disputes, complicated valuation cases, construction cases, cases where parties have waived the right to a jury trial in a contract, or simply cases where the parties have determined it's better to have a court decide these complicated issues rather than a jury. We believe a presumption in the rule that these are streamlined cases will cause further motion practice or dispute or delay or unmeetable deadlines based upon the timelines addressed by those cases by a general order. The second thing I would like to discuss is proportionality. Section.
So how would you treat them?
I would just not have a presumption in the rule that they are streamlined. Okay. It would go based upon the other types of ways that they're categorized in the rule. The second matter which we'd like to discuss is we propose that the rules of the concepts of proportionality and the scope of discovery reflected in Rule 26 of the federal rules be adopted in these rules. The concept of proportionality already exists in the Florida rules in regards to electronically stored information and discovery of it, and it would, we think, further the goals of the work group to more efficiently resolve cases by including this. It's just another tool that the trial courts can use to speed along the discovery disputes as they come and resolve the abundance of these discovery disputes that are happening every day in every motion calendar or special set hearings before the court. It would also increase access to the courts for a number of citizens if there's less discovery expense and less motion practice related to discovery, and therefore increasing access to the courts. The objectives of the case management in
Sorry, can I ask you about that? I mean, because I'm kind of presumptively in favor of proportionality, but it seems like the main pushback on it is that it will be sort of a, you know, litigation kind of generator rather than something that makes things more efficient. What's your response to that?
The circuit court judges are making these decisions already in sort of other ways or considering other standards. This standard is going to give them a tool in order to weigh these things. It may take the same amount of time, may take more time. I haven't studied that issue. But it's the tool that is working in the federal courts to resolve discovery disputes, and it gives the circuit court judges the benefit of the wealth of cases by district court judges and federal magistrate judges who have written extensively on these proportionality issues more often than our district courts of appeal have an opportunity to do so based upon how the appellate standards work. As I understand the work group's comment is they propose a delay of this. I'm not sure if they're necessarily opposed to it, but I don't wish to put words in their mouth. The section believes this is as good a time as any to include those changes, as the practitioners, assuming the court makes changes, are going to be attuned to rule changes and will have the time to look at them and be focusing on rule changes at this time. If there are no other comments?
Going back to the non-jury issue you brought up, are you suggesting that all non-jury trials not be streamlined? Or?
No, they could be cases that are streamlined,
right.
But the presumption that bench trials are streamlined is what we take issue with.
Okay.
Thank you.
Thank you.
And we appreciate the section's comments.
Thank you for your time.
Mr. Maros.
Mr. Chief Justice Muniz, justices of this honorable court, and may it please this court. George Maros and Tara Price, speaking on behalf of the American Tort Reform Association. We ask this court to reject adoption of proposed Rule 1.190B. Far from this court's laudable efforts to improve resolution of civil cases, this rule would increase litigation, not streamline it. Equally troublesome, the proposed rule would collide with the legislative policy choices as they were enacted in Section 768.81 Florida statutes. 5 decades ago, Florida established that a defendant must pay for his or her own wrongdoing, but not for the wrongdoing of another. This court has consistently upheld this rule of fairness, beginning with Hoffman versus Jones in 1973, Fabre versus Marin in 1993, and most recently in the 2021 decision of Crime v. Looney out of the first DCA, authored per curiam by Judge Bride Thomas, Rachel Nordby, and Robert Long. Proposed Rule 1.190B differs in material respect from this established law. A defendant seeking to amend his or her complaint and add a wrongdoer must do so within 15 days of when the defendant, quote, knew or should have known of the defense, or provide good cause and the absence of prejudice for taking longer. No such limitation currently exists in Florida law. And the work group's report provides no insight or discussion as to why this draconian limitation is necessary or helpful. To the contrary, the proposed rule would embroil state court judges and litigants in many trials over the meaning and application of opaque phrases like knew or reasonably should have known, or the exercise of due diligence. And without being facetious, Your Honors, this court did not ask for proposed rules that would add to the cost of litigation or to delay resolution of civil cases. We urge the court to propose Rule 1.190, and we greatly appreciate your time.
I'm curious, just your client and the other groups that are kind of focused on litigation reform. It seemed like there wasn't a ton of enthusiasm for the changes in general, and I'm just curious if you could just sort of speak to the kind of overall reaction, and if there's any priorities that you would want the court to be aware of from that perspective.
With regard to the comments, I'm sorry.
Yeah, with regard to the proposed rules in general, if you could just kind of speak more globally to your views and your client's views on that.
Certainly, and we have detailed requests regarding the challenges with regard to meet and confer, challenges with regard to have additional or require additional discovery, such as in the federal court, that can be extraordinarily burdensome if, in fact, that discovery is provided too late or with too much lack of effort to get discovery resolved and to have a meaningful response. And so we certainly believe that there are a number of rules that can enhance the fairness of the process and can enhance a effective resolution of some of the cases that are often more a matter of fighting discovery battles than they are getting to the merits of the case. And so that's essentially, in summary, what we have submitted in the comments.
Thanks.
Good morning, Your Honors. Sarah Goldfarb for the statewide guardian ad litem office. Florida courts have an obligation to act in the best interest of children falling under their jurisdiction. Amending Rule 1.010, as proposed by the guardian ad litem office, to include as an exception to the civil rules matters to which the juvenile rules apply, further the work groups and this court's goals to streamline litigation and decrease delays, as well as promote efficiency in the resolution of both dependency and civil cases. The juvenile rules are intended to apply exclusively to juvenile proceedings. This is clear from Florida Statute 39.013, subsection 1, and Florida Rule of Juvenile Procedure 8.000, both of which refer to the juvenile rules and only the juvenile rules as applying to Chapter 39 proceedings. This is further explained in this court's 1992 committee note, which expressly states that the juvenile rules are to be self-contained without need of further reference to the civil rules. Despite this clear language in the statute and in the rule itself, Florida courts have not been resolving this issue in a uniform manner. This is leading to substantial delays in permanency for children and is allowing the civil rules to be used to circumvent dependency proceedings by the initiation of litigation by initiating litigation under the civil rules in matters where it should be applied to the juvenile cases. The juvenile rules and Title 39 were created with a very specific purpose: to promote permanency for children and to achieve speedy resolution of those cases while respecting the fundamental rights of parents and the parents' patriotic interests of the state. The misuse of the civil rules undercuts that purpose and is dragging cases out, creating, in some cases, delays of more than 2 years while things are resolved in a manner outside that what's encompassed by the juvenile rules.
So did the amendment that the work group made to 1.010 in their proposal, does that address your issue? Or?
Yes, that was in concert with our comment. Okay. That was added.
So assuming that were to be part of whatever got adopted, that would satisfy your
That
concerns?
satisfies the concern. Primarily the litigants who are using the civil rules are non-parties to dependency litigation. They are intending to assert some interest of their own that they think should be heard in the dependency, but is not otherwise provided for in the juvenile rules. And in that way, it's circumventing the very specific process that's been put in place. Clarity is needed to protect the best interests of children and ensure their best interests are protected. The amendment is consistent with the work group's goals to achieve consistency in the law and streamline cases and reduce delay in both the civil context and in dependency laws. I have seen my time for any further questions.
Thank you very much.
Thank you.
May it please the court, my name is Sarah Weitz and I'm a vice chair of the Appellate Court Rules Committee. The committee appreciates the work group's narrowing of the issues somewhat in its September 19th response, so I'll focus on two remaining flaws that the committee perceives in the rule proposals. First, Rule 1.460B10 proposes a gross abuse of discretion in review of orders granting or denying continuances of trial. The work group's initial proposal also included a presumption of correctness that the work group conceded was unnecessary in this rule and struck it. The other rule that the committee has discussed in its comment is Rule 1.271G, which proposes expediting appeals arising from the pretrial coordination courts. Turning first to the gross abuse of discretion standard that is proposed in Rule 1.460, the committee disfavors standards of review in the civil rule set generally and has particular concerns about the gross abuse of discretion standard in this rule. The committee's research indicated that standards of review are part of the decision about what standard of review applies is part of the judicial decision-making process. It's part of the identification of the exact nature of the issue pending before the court, whether it's a factual issue, a legal issue, or a mix of both. A rules-based standard of review would inhibit that part of the judicial decision-making process since the title of the order on review does not necessarily dictate the nature of the issue actually pending before the courts.
And I'm sure, and I apologize if your comment addressed this, and I'm sure that there are appellate decisions that have referred to things as having been a gross abuse of discretion, but is that, as a standard of review, is that even a thing?
Your Honor, that is something that is very much a concern of the committee. This court did define abuse of discretion in the Kanakaris decision in 1980, but the gross abuse of discretion standard is poorly defined, or it's not well defined.
I mean, if an abuse of discretion by definition is something that no reasonable person would have done, then it seems like that. I don't know what goes beyond that.
Correct, and the Fourth District Court of Appeal actually noted that it's well nigh impossible to define a meaningful distinction between these two standards. So orders granting or denying continuances of trial have been reviewed for or abuse of discretion for more than a century. The gross abuse of discretion standard is not necessary since it is, already an abuse of discretion standard, and the fact that the gross abuse of discretion standard is not clearly defined and not regularly used in practice has the potential to open up lack of clarity or inconsistency among the case law as judges try to grapple with what's gross abuse of discretion versus what's regular abuse of discretion. The committee would also note that parties who seek immediate review of these orders granting or denying continuances of trial currently have to satisfy the certiorari standard, which is a more exacting standard. So the gross abuse of discretion standard, we disfavor, as we indicated in our comment, the committee disfavors including any standard of review, but particularly the gross abuse of discretion standard of review in Rule 1.460. The second rule that the committee discussed in its comment is Rule 1.271G, which concerns or which proposes that orders from pretrial coordination courts be appellate review be expedited of those orders. The concerns that we had is that the language in the proposed rule is still directive. The work group indicated in its response it wanted to make the language more suggestive for both of these proposals that I've discussed today, but it uses the word should, which is still fairly directive to expedite review of these kinds of cases. The appellate rules, which obviously govern appellate proceedings, do contain expedite requirements for certain kinds of cases involving highly sensitive, if not constitutional, rights that are also time sensitive in nature. So parental consent regarding terminations of pregnancy, dependency cases, terminations of parental rights, those are all cases that the courts are encouraged to expedite. The orders arising from the pretrial coordination courts, meanwhile, the proposal here relates to all orders coming out of those courts, and the kinds of cases that will be handled by those courts are not clearly defined in the rule. There are examples suggested in the work group report, but the actual types of cases are not defined, so the committee disfavors that requirement as well, and I do see my time is up. Thank you. I'll conclude here.
May it please the court. My name is Tom Hall. I'm of counsel with Bishop and Mills, and I'm here. The comments are my own. I just want to follow up what Ms. Weiss said, and that is addressing the two places where they put a standard review in the civil rules. It was in 1.1460 and 1.275. I don't think they belong there because standards of review are substantive law. They are not procedural. There are no standards of review in Florida's appellate rules. There are no standards of review in federal rules as well. The standards of review are as substantive rules, as substantive law, they simply don't belong in the procedural rules. I think one of the things you'd run into if you adopt it as part of this thing, I think you'd get immediate challenges to the rule as violating Article 5, Section 2A, which says the court sets the procedural rules for the operation of the court system. I think it's just, aside what the things that Ms. Weiss made about we don't think it's necessary, period. I think with its substantive law, they're suggesting you put it in a rule. The Appellate Court Rules Committee did give one example of where the court did put a standard review in one of the rules, but they did so after changing the law in an actual case or controversy, and then put it in the rule so it was there so people could find it. There are some other examples where that's done, but the court has, to my knowledge, never adopted a standard of review in a rules case. So I would urge that the court not do that and reject the rule. If you decide to do it, at least put them in the appellate rules so people who are doing appeals can find them, but ultimately don't adopt them. Thank you.
Morning. May it please the court. Greer Presley on behalf of the Probate Rules Committee, and I'd like to begin by thanking the court for the opportunity this morning and also thanking the work group for its efforts. And I do believe that we're largely marching to the beat of the same drum when it comes to probate, trust, and guardianship proceedings. I'd like to preface my remarks this morning by saying that Mr. Goldman will be appearing on behalf of the reptile section following me, and we have coordinated our remarks for the benefit of the court this morning, and I will be addressing three discrete proposed fixes to the work group's products, and then Mr. Goldman in his remarks will explain why these fixes are appropriate and necessary from a policy perspective. For ease of reference, I hope that it's appropriate to refer to probate, guardianship, and trust proceedings as PGT proceedings, which the work group did in its response. As the work group's response indicates on page 29, the Probate Rules Committee and the Reptile Section suggested that PGT proceedings be exempted from the case management procedures of Rule 1.200 and the meet and confer procedures of Rule 1.160 and 1.161. At the same page of its response, the work group agreed in principle with the comments filed by the Probate Rules Committee and the Reptile Section, recognizing that the work group perhaps lacked the expertise to address the PGT issues raised by the comments. As Mr. Goldman will point out, I believe, in his remarks to follow, the work group likely simply misapprehended the practical effect of existing Rule 1.010, which in practice does not in fact exclude PGT proceedings from the requirements of the Rules of Civil Procedure. So I would like to use the balance of my time allotment today to quickly address a couple of areas that we believe were simply lost in translation in what I believe was the work group's intent to exempt PGT proceedings from 1.200, 1.160, and 1.161, and to propose what I believe to be an easy targeted fix to accomplish the differential treatment of PGT proceedings when it comes to those particular rules. First, Rule 1.200. In Appendix A of the work group's response, the work group's carve-out of PGT proceedings in 1.200B4 presumably inadvertently does not capture trust proceedings, which are governed by Chapter 736 Florida statutes. So the easy fix in 1.200B4 would simply be to add 736 to the list of reference chapters there. Second, to properly accomplish the exemption, and we believe the intended exemption of PGT proceedings in Rules 1.160 and 1.161, we would suggest simply adding the same style of carve-out from 1.1200B4 to 1.160A and 1.16A. And we have prepared proposed carve-out language for the consideration of the work group and the court, if that would perhaps be helpful. And I thank you for your time today.
Thank you.
Good morning, and may it please the court. Bob Goldman on behalf of the Real Property, Probate, and Trust Law section of the Florida Bar. I do want to rely on our comments filed May 27th, 2022, primarily because I'm going to speed talk my way through 3 minutes, and a lot of what is important to look at starts at page 12 of that item, of those comments. Like Greer Presley, I was really moved by the work of the work group and its response to our comments, and recognizing that probate, guardianship, and trust law is just different. I also appreciate Judge Morris's comment earlier today about the fact that the work group is not just considering lawyers and judges, but of the people of Florida. Death hits all the people of Florida. Most of them have to go through some form of probate proceeding. People live longer and end up in guardianships. So this is very real to the people of Florida. Probate, unlike a civil case, isn't a plaintiff, a defendant, and a single final judgment. It's a series of proceedings, all of which may end up with final appealable judgments. For example, and this is by no means everything, petitions for administration to administer the estate, petitions for family allowance, petitions to determine homestead, petitions for elective share, petitions to construe a will, petitions for discharge and to approve final accountings. And some of those proceedings are actually adversary proceedings under Rule 5.025 of the Florida Probate Rules, and therefore the civil rules actually do apply to them. But these proceedings are adversary in air quotes because 9 times out of 10, there's nobody on the other side. You have to figure that out. You have to notice people and work with them. And of course, a personal representative is a fiduciary for not just the beneficiaries, also for other interested persons, like creditors. Interested persons, a defined term under our law 731-201 sub 23 defines it as anybody likely to be affected by a proceeding. Well, in this concatenation of proceedings under an umbrella of an estate administration, those may be different people every single time. So the application of 1.200, the application of 1.6, 160 and 161 may happen several times, costing the beneficiaries of an estate a lot of money, costing the ward of a guardianship a lot of money that's supposed to be there to protect the ward. So these are primary concerns, and I should add, I mentioned that some of these proceedings are deemed adversary under 5.025. Any proceeding under the guardianship law and probate law can be designated an adversary proceeding by any interested person, thereby triggering application of the civil rules. So it could become quite a mess. Trust. The guardianship stuff is pretty much like probate. The only difference is there's a lot more protection there. Why? You're protecting the privacy rights of the alleged ward, alleged incapacitated person, then privacy rights all through that person's life, because they're still out there and living, and there are a lot of checks and balances already in that process. Trust 736-0201, and I'll wrap it up, are set up for complaints and the civil proceedings to apply, civil procedure rules to apply. But in fact, like probate, almost none of those proceedings are adversary in nature at all. So in addition, the work group suggested on page 29 that maybe they did not have any expertise on that committee in this area, and suggested creating some form of work group to analyze this and figure out, can we do better? Because we're constantly trying to do better.
This is a little far field, and I
Yes,
really
Justice
think your points are well taken, and I understand your perspective on this.
Yes, sir.
But I've seen numbers not too long ago showing that one of the dockets in our circuit courts that is kind of bogged down is the probate court docket. Mm-hmm. I don't know if that's consistent with your experience. As we've looked at the numbers coming out of the pandemic, other dockets are moving. The probate docket seems to, and actually in some cases the backlog has gotten worse since we have gone back to more or less normal court proceedings. Yeah. Do you have any insight into why that is happening? And again, maybe this is a subject for another day. I mean, I know we're not going to solve it here, but I'm just curious.
Well, strangely, and being very involved in this section of the bar, I'm of course hearing all the time, and in fact going to a meeting right after this, from all over the state. And for example, in Collier County, where I do a good bit of my practice, it's nothing. It moves. And a lot of it moves by mail. Again, because you send out the notices, nobody comes back contesting, done. And move on to the next part of that proceeding. In Miami, respectfully, it's a mess. My partners don't like to do the probates in Miami because it's just too bogged down. The litigation side of it that looks more like civil litigation goes faster. Palm Beach, I've had no problems, none whatsoever.
So basically it depends on the circuit.
I think so, Judge. I really do think that's the bottom line, but I'm speaking anecdotally too from my own experiences. Thank you for your.
So is your point that as the study of this goes on and the refinements, that there needs to be kind of an appreciation and focus on this, or are you saying that there are specific things in here that are kind of directly of making it worse for you guys that we need to be aware of?
So Mr. Presley raised the three, and those are the specific items, and he's given hard copy, if you will, to the working group on how to fix those, one of which they clearly say in their papers they were going to fix, and I think the other two as well.
Okay.
That puts us at sort of a stasis point,
right,
where we can then sit down and do our own self-examination,
okay,
and see what we can do better. Thank you, Judge.
Thank you.
Mr. Chief Justice, members of the court, thank you for the opportunity to speak here. And I've made the comments just on my own behalf. And I make those as an experienced probate and trust lawyer. My entire practice in Florida has involved the administration of estates. And when I saw the work group's work, at first I didn't think that we really need to have a comment, because I didn't think they were trying to deal with the probate and guardianship administrations. But realizing that that could be interpreted that way, and hearing the prior two commenters' very well-reasoned arguments, I felt it was necessary to file the comment and make the 3 points that I made. First, to Justice Kennedy's observation about the increased number of probates. I think that we may be asking too much unnecessarily of our courts for routine uncontested probates. The probate administrations that Mr. Goldman described that have a lot of these subsidiary actions, family allowance, elective share, those that require judicial decision-making need to stay in a system that gets them in front of a judge. But there are many, many routine, uncontested probate administrations that are akin to administrations under revocable trusts. And throughout the country, other states don't require judicial action on those routine, uncontested probate proceedings. And so I would hope that this court would direct whatever group you all believe is appropriate to look into how we might set up this parallel system that would be available for the uncontested routine probate administrations. The second point that I would make, and again this ties in nicely to Mr. Goldman's comments, is that many, many trust administration legal proceedings should be governed by a set of rules that are similar to probate rules, but they're not right now. And so if in a world where you have a will that pours over the estate to the revocable trust, and someone wants to contest both of those documents, having been executed at the same time by the same person under the same circumstances, they have to file a will contest in probate, and they have to file a separate trust contest in civil. And then often those get consolidated because the judicial efficiencies can work. But why have those separate set of rules? Why not expand the scope of what we now call the Florida probate rules, which already includes guardianship, to also include trust administrations? And then the final point in my comment has to do with the recognition that I think we can have a better recognition that many of these trust matters truly are in rem. But if you look at the cases that get filed, it's often trustee versus beneficiaries. And you will describe those beneficiaries sometimes as nominal defendants. But it still puts them in a posture that really doesn't make sense, because all we're doing is talking about what ought to happen to the race of the trust. We don't need personal jurisdiction over the beneficiaries to take money from them or to cause them to do any other items. So with that, I appreciate the work group's response. I know that the work group has indicated that at least the case management issues should be further studied by a group with a subject matter expert. I would request that you don't stop just at case management, but you also address some of these other concerns. Thank you.
We're ready for you.
May it please the court. I'm Peter Webster, and I apologize. I thought Mr. Solomon was going to be speaking before me, but apparently he's not. I'm here to speak today primarily on my own behalf, as well as on behalf of my law partner, Bruce Berman, regarding some observations about the work group's proposals as a package. But I've also been asked just briefly to highlight for the court, on behalf of the law firms of Jones Day, Hill, Warden, Henderson, and King and Spalding, their concerns about the pretrial coordination court proposed in Rule 1.271. As the court probably is aware, those three firms do a lot of the mass tort type of litigation in Florida and around the country. In a nutshell, their position, and they've all filed comments, their position is that the pretrial coordination court is unnecessary and it's a bad idea for several reasons, primarily because it deprives individual circuit chief judges of the discretion and the flexibility to manage these types of mass cases. The obvious ones that come to mind are asbestos cases in the past and today tobacco cases. This proposal would deprive individual chief judges of the opportunity to deal with those kinds of cases according to local requirements. And the other problem they note is that the proposal runs afoul of a longstanding law of the case principles because it would require trial judges to follow decisions of the pretrial coordination court, including through the trial. And I'll point out for the court that both the Fourth Judicial Circuit and the Eighth Judicial Circuit are in total agreement with the comments of those three law firms. The Fourth Circuit in particular, in a comment that was authored by Judge Del Wallace, noted that they have had a process in place for some time, from the days when I was on that court, when we were dealing with asbestos litigation, and it's worked well for 40 years, and they shouldn't be deprived of the ability to use that. So I just wanted to highlight that for the court. Now I'd like to go ahead and address some concerns that my partner Bruce Berman and I have about the proposals as a package. And let me start by saying that if our court system were a business, we would certainly not consider changes of this magnitude without first conducting a meaningful, realistic, fact-based cost-benefit analysis. Yet the work group has conceded in its final report that most of its proposals are based on anecdotes and conventional wisdom rather than hard data that a problem even exists, let alone that the particular proposals will solve the perceived problem. As the Fourth Circuit's civil judges have warned, these kinds of sweeping changes shouldn't be implemented until we have made a realistic determination of what the cost of that implementation will entail.
Can I just quickly interrupt
Yes,
you? So I understand that there's no study that has addressed anything that looked at everything altogether, but it seems like there's tons of evidence that has been developed over a pretty long period of time that case management and more active case management in particular bears fruit and increases efficiency. So if we at least focus on that aspect of it, would you agree that that's not a shot in the dark?
I would agree with that. And for what it's worth, I'll tell you that in 1987, when I was assigned to a civil division in Jacksonville, I instituted my own form of active case management, and it dramatically reduced the number of pending cases I had. I think we all know that the surest way to deal with civil litigation, because most cases settle before trial, is early on set a firm trial date and make sure that everyone understands that if you're set for trial, your case will be tried during that term. That's the best way to ensure settlement of civil cases. So I agree that some form of active case management is absolutely necessary. I think what we have here is far too complicated, far too expensive for all of the reasons other speakers have already addressed. The other.
In particular, could you address 1.200? I mean, the differential or the differentiated case management, that kind of process there. I mean, I understand we've got a lot of things that are interrelated, but just that part of it.
And I agree with what's already been said regarding the differential case management order that Your Honor instituted during the pandemic. That has been a dramatic and significant help for the trial courts, because, for one reason, because it does impose deadlines. So trial lawyers deal with squeaky wheels, and if you know that you're going to trial on a certain date and you have to get all these things done in advance of that, you're much more likely to do that or to settle the case. The other aspects of the package proposal that my partner and I think are both valid and deserve serious consideration are the initial disclosure provision in Rule 1.280A and the proposed reversion to what had in the past been the rule in Florida but was changed regarding a continuing duty to supplement discovery. Those two, together with some form of meaningful active case management, will have a significant impact. They should, however, I would suggest to you, be considered individually rather than as part of a huge package like we're seeing here. We're talking about a sea change here in how Florida's courts handle civil cases. And I'm going to suggest to you that even a cursory review of the proposed package reveals that it is without question going to require lawyers to expend considerably more time and therefore clients to spend considerably more money without any real promise that the result will be more fair, more timely, or ultimately more expeditious.
Counsel, could I ask you this, because I know your experience. What do you think about the proportionality requirement for discovery? Because we've heard two different views here. One is that's going to bog the courts down in more litigation. The other view is that it will actually, that the kind of things that would be litigated there are already being litigated anyway under other rubrics, but it would give a kind of a clearer marching order to the court as to what the standard should be.
Well, trial judges dislike discovery disputes more than almost any other aspect of their work. And so to the extent they can be avoided, that's generally a good thing. The way the federal courts do it, of course, is they use magistrates. So the federal district judges don't have to dirty their hands with that sort of stuff. But I think the initial disclosure requirement and the continuing duty to disclose requirement will go a long way to solving the same kinds of problems that proportionality would deal with. And I do agree that proportionality has the potential to create a great deal more work for not only the courts, but for the lawyers as well. And as you've all already acknowledged, we're here about what's going to be most efficient, but also least expensive for litigants in this state. And if we can avoid increasing costs, we should do that. And I'm afraid that the proportionality provisions would have just the opposite effect.
We want to take advantage of your insights here. So on the motions front, I know I guess you think that you're not a supporter of what's been proposed particularly, but are there things that would improve the system that are, that can be done without so much disruption that you think would be a step forward?
I've been on both sides. I've seen these problems from the bench side, and now for the last almost 12 years, I've been a litigator in both the appellate and the trial courts. And the single one thing that would help more than anything to deal with motion practice is to find some way to expeditiously automate setting motions for hearings. And that's not something judges spend a lot of time on, but their JAs just pull out their hair over these kinds of problems. And not infrequently, if there's one side that has no interest in having the matter heard anytime soon, they just won't agree to any of the dates that are available. And so they delay things longer and longer. Now, with regard to the proposals in the package are just far too complicated. They're internally irreconcilable. 160 and 161 are, I think, irreconcilable. The time limits within which the trial judge has to act are dramatically overly optimistic. Trial judges are hearing cases 8 hours a day, 5 days a week. When are they going to sit down and review motions to decide whether they're going to grant a hearing or not? There are some matters that don't need hearings, but my feeling, and I know my partner Bruce Berman's feeling, has been that more often than not, these kinds of issues can be resolved more quickly by having a hearing than they could be if the judge had to sit down, find time, sit down, review the papers, and then decide how she's going to rule, and then write an order. The way things work now, most of the time, the judge will decide the issue at the hearing and leave it to one of the parties to draft a proposed order.
That has, in reading this proposal, that was always my impression, having sat in a civil division as a trial judge. When do I do this? If I'm sitting up here, taking the bench around 9:30 or so after you finish the uniform motion calendar, and you're there until 5, maybe 6. So when do I do this 5 boxes of documents somebody just dropped off for me to do an in-camera inspection to see if they're trade secrets or not?
Well, and Justice Labarga, I'll tell you how I did it. When I was a trial judge, I would set aside Friday afternoons from 2 to 6 to draft orders in complicated motions. And unfortunately, and I hope you'll allow me one anecdote, unfortunately, Judge Bruce Anderson from the Fourth Circuit has reminded me that when he was a young assistant state attorney in Jacksonville, they learned very quickly that on Friday afternoons I was often one of few circuit judges in the courthouse, and so they would come to me with search and arrest warrants, and that made it somewhat more difficult for me to draft orders. But your point is a valid point. Long story short, if you're holding hearings 5 days a week from 8 or 8:30 to 5 or 5:30, it's awfully difficult to find time not only to decide the issues that are in front of you, but to decide whether you're going to have a hearing to decide the issues.
Well, that fits perfectly in the federal system, where you have all these staff attorneys and you have magistrates that deal with that, and the staff attorney walks into your office and says, this is one case you might want to have a hearing on. We don't have that.
Well, and that's another one of the problems with the proposals as a package. It assumes a federal-type system with adequate staff, not only elbow staff, but central staff, adequate automation, and probably most important, life tenure. You know, we all know that if you have to run in a contested election, which is almost always the case in South Florida now, it's going to be harder for you. It's just a fact of life to impose monetary sanctions on a lawyer for not doing what he or she ought to be doing. You know, we're talking about all these sanction rules. We have a sanction rule in 1.380 now that uses the word shall. And those of us who are litigating discovery disputes know how infrequently shall is construed to mean shall when it comes to 1.380B. I know I'm way over my time.
So is your point, though, that to the extent that it seemed like obviously some of the motivation for the change, for the wording changes in here was to kind of help judges by making things more mandatory, is your point that because we already have something mandatory that it won't make any difference, or do you think that what they're doing would be a positive step, or what's your take on that?
I think that it may not make any difference for all of the reasons we've discussed, but I'm more concerned, I mean, will it make a difference? The answer to that is, you know, judges just have to start doing what the rules tell them to do now. But my concern with the new proposed rules regarding sanctions is that it seems to be there's a sanction for everything. And it doesn't matter whether it's willful or not anymore. It's almost a no-fault sanction situation.
Well, on that, and I realize that we've got these gray areas where, you know, maybe a different judge would have decided it the other way, okay? And so, but putting that aside, we've got the categories of things that are just bad faith actions. And then we have the things that are also just negligence. If you, putting aside the kind of that gray area, do you think it's problematic for us to have some sort of system that imposes some sort of sanction with respect to negligent conduct of attorneys in litigation that has consequences for the way cases go and the whole system?
Well, let me just say first, I don't see a lot of situations where failure to comply with discovery is just negligent, because virtually, at least all of the circuits I appear in with any regularity, the judges all have meet and confer requirements already. And so it's very difficult just negligently not to comply before you have to get to a hearing. It's almost always intentional. And with regard to your question about whether we should have some sort of sanctions, of course we should. When it's intentional, there's no question we should, but we have it now in 3.80.
I meant specifically for negligent.
I just don't see that, Justice King. I mean, I don't see a lot of situations where it's negligent. Thank you.
Thank you.
May it please the Court, Paul Regensdorf on behalf of nobody but myself. I'm a longtime rules person. I've been on rules committees for 46 years, longer than some of you have been alive. I have a lot of comments I'd like to respond to. I'm told I was supposed to answer your questions. That was not my idea. What I really want to talk about first, and if I have a couple of minutes, I'll address a couple of little points. What I really would like to address is something that Justice Kennedy spoke about, and that is that we're all here on the same team. We're all here working for the public. What I'm raising with you folks at the end of this process, I'm the last commenter today, is this. There have been rules committees that I've worked on efficiently and effectively for a lot of years, but there's anecdotal comments of all kinds of concern that some members of this court have had about some committees from time to time, and you'd have to be an idiot not to see the fact that you have appointed work groups to kind of do the jobs that rules committees have frequently done in the past. This work group has done a magnificent job of gathering material. Of course, they had tremendous staff support, and I think they had tremendous assistance from this court to give some guidance. I don't know that for a fact, but I think so because the work was done behind the curtain. My main point is simply this. Is it time to at least consider, are we amending rules in the proper way? We still have what should be called an adversary system, where we're not allowed to communicate with you. The first time we raise issues with you significantly is either in writing, a kind of a bad way to do it, or over this little timer here. I suggest that the time has long since passed when the bar and the court should be raising these issues not over a timer, but perhaps over a cup of coffee, or perhaps better, a Negra Modelo, and do it in a collaborative fashion. Many states do that. But to raise these bulk issues in this adversary system where we're not allowed to communicate and give you our thoughts and, more importantly, get your thoughts is really doing the public a disservice. And as a result, we've got this massive project that I don't think is going to be passed in its entirety. Some of it's good, some of it's got questions, but I just raise the issue, is it time to step back and see how we do this? So that's really my point, is to ask you to consider working with the bar in doing that. But if I could just touch a couple quick things. Justice Curiel, the continuance question, the first motion for continuance, you used the present rule. The second motion, you used the no way rule that's been proposed. That's what they do in disqualifications. Why can't we do that in continuances? I think it's an excellent idea. You sort of a one free bite type approach. Treat judges with the discretion they deserve. Allow them to have that discretion. Don't pen them in, and allow lawyers to act like professionals and treat them like professionals. And then when they don't, hammer them. Justice Polson, you said, well, what do you do about those few cases that get off track? Well, why don't we treat all cases with professionalism, assume professionalism, and then, and only then, hammer them with these difficult imposing sanctions? Why do we have to start by assuming no discretion on the trial court and lack of professionalism on the attorneys? It bothers me as a professional. Frankly, in terms of the questions you raised, Chief Justice, about Rule 1.200, I would urge this court to look at the Rules Committee. I'm on civil rules. We've worked long and hard on these things. Well, our proposal for Rule 1.280, one of the problems, I think, and really the only big problem with the case management, because it has done a wonderful job, the administrative order, it's brought things along, but the new final proposal is front-loading a lot of stuff on the judge. 1.280 takes some of that off of the judge and puts it on attorneys as professionals up front to get the job done in terms of disclosures, scheduling, etc. And then if the lawyers don't do their professional job, you give the court discretion to impose a more significant and mandatory form of 1.280. Respectfully, I think that's a professional system. It lets lawyers do their job, and then if they don't, then the hammer comes down. It just bothers me, and trust me, my practice is behind me. It's not ahead of me. By the time you get these rules sorted out, I won't be practicing very much. So I'm really here trying to help the bar and the public get a system that works. Let's treat lawyers like professionals until they're not, and let's give judges the discretion that I think they ought to have. When you get into the case management order, there was some discussion. I know Judge Lee disagrees with me. I'm sorry. I really do not like the idea of allowing 20 circuits or 67 counties to have different practices for case management systems. I've worked long and hard on the rules of judicial administration,
Well, isn't that what we have now? Because there are some, at least I believe, prior to the emergency measure, there have been some circuits that have done some fairly aggressive case management.
You bet.
And some others that have not done much at all.
And that is my point. For one thing, it's not right. We're a system of court. We're a state of Florida. We have a court system, not a court amalgamation of 20 circuits.
But to accomplish what you're talking about, we have to have change.
Absolutely. I'm not against a centralized case management order. Not at all. I'm in favor of it.
You're talking about the comment that's whoever one of the other commenters said that they didn't like the carve out in the proposal that said that all this could be
absolutely. I see absolutely no. And for lawyers, in the old days, I only practiced in Broward County for a while, and then I gradually went to West Palm and Miami, and then I was all over the state, and many people are these days. To learn all the different circuits practices is just really it's wrong. It doesn't create an effective system. So let's get rid of those carve-outs. Make a uniform system. I suggest bringing in the proposed the Civil Rules 1.280 process first. Let the lawyers do their job as professionals first. Let the judges do their discretionary job, and then bring the judges in for the next step after that first case management conference. Whatever. So rather than dumping it all on the judge up front. This 1.160, Megan, Luca, and I, and Cosme Caballero proposed a rule that I think is a whole lot better than the motion and hearing rule. The proposals, respectfully, God bless you guys for doing all the work that you did. I don't think those can be managed without years of training. It's a complicated process, but throw that back to civil rules. Let's see if we can clean that up and get a better rule. We've given you one proposal in the civil rules for those. And those are choke points. You were looking for choke points before. One of them is motions and hearings, But the comment that Peter Webster just made is so desperately true that a lot of little things can be handled faster for judges by just getting it to a 5-minute hearing, getting it to a motion calendar. Make sure the rule allows that. The number of touches that have to be done under the present rule, where a judge has to decide this before you can file the motion, or file this before you get a supplementum read, then decide whether to have a hearing or not, and then have a hearing and then make a decision. Those are things that, from my experience in talking with judges in Broward and elsewhere, they just don't have time. They're just going to default to schedule it for hearing. I'll think about it then. Well, I think that's in part somewhat of a reality with the rule that we have. Maybe if we make it simpler, we can get more decisions to judges quicker. They can make decisions in those few cases, or many, where the judge feels comfortable doing it on the papers. Get him or her the papers at an appropriate time, then the judge can act. And then if the judge decides to have a hearing, great. Then you have a hearing and proceed in that fashion. I've way overstayed my welcome. You got. Or do you want me to take their time as well? I'll be happy to. You've got to hear from the proponents, and they've got some wonderful things to say. Thank you very much, Frank. Appreciate your criticism.
Thank you. Okay, we'll take a break until noon, and then we'll hear from the work group. Thank you.
All right.
Good afternoon, and may it please the court. You may recognize me. I'm Jennifer Bailey, the apparently now notorious Judge Jennifer Bailey from the Administrative Judge of Circuit Civil in Miami, Florida for the 11th Judicial Circuit. What I'd like to do, my focus is going to be on case management and the pretrial coordination court, but I'd like to start by trying to answer some of the questions that came up earlier. One comment, though, I need to start with. There is no curtain. This work group received its marching orders from then Chief Justice Kennedy. We went out and started working. We drafted our report. Our report was circulated to multiple stakeholders: civil rules, judicial administration, trial court performance and accountability. Before we finalized the report, when the report went out, we took all these commenters, we are so grateful for helping us make a better product. We took 75% of the comments that those commenters made, probably, maybe more, and made them part
And when I said earlier it was 2 years, it was 3 years.
3 years.
3 years.
3 years we've been at this. During COVID.
Pandemic time. Yeah.
And it's been a blast. But let me first of all say that there's a fundamental truth that's being overlooked here that started this. Individuals and businesses are losing faith that our courts can resolve their cases within a reasonable time and at reasonable cost. And to your question, Justice Curiel, state courts across the country are grappling with this same issue in civil courts. People just don't believe, small businesses don't believe that they can get their contracts enforced within a reasonable period of time. Private individuals don't think coming to court is going to make any difference. And as I said, the work of the
Well, I think the evidence of that is if you look at alternative dispute resolution, it is exploding because parties perceive that as a more reliable way than our product at solving their problems.
And that's for the people that can access that. If you look at Rebecca Sandifer's work for the American Bar Foundation, the regular people, they just don't come to court. They just abandon hope that their problems are capable of solution by the third branch of government. So that's the problem we face. That's the problem that was recognized when we were appointed. And with, as we all say, with all due respect, the commenters who are defending the status quo mistakenly believe the status quo is working, and it's not. That's why we were appointed. Civil justice costs too much, and it takes too long. The proposals here, while admittedly imperfect, seek to benefit our users, the people and businesses who bring their problems to court to be solved by eliminating the strategic and financial incentives, as you point out, Justice Curiel, to abuse the civil litigation process. When you look at the incentives under the current rule, for example, discovery, I know we've all talked about discovery. We put all the cost of enforcement on the innocent party. You submit discovery, the other side doesn't answer. You have to meet and confer on a motion to compel. They may take an agreed order, they may still not answer. You then have to come to court to enforce. All that work has been on the party that asked for the discovery and didn't get it. And then they show up and take an agreed order or say, that's fine, Judge, I'll comply, I need two weeks. Who does that benefit? What does that incentivize? We need to deliver 21st century justice, no matter how comfortable we are with 19th century procedures. We can no longer rely on the fiction that the competing interests of the parties will generate the timely momentum to resolve the case, especially where so many folks in our system are unrepresented and where others exploit the system. So, case management, it's been part of the branch's long-range plan since at least 2008. The time standards, Rule 2.2545, case management, has long required courts to take charge of the progress of the case to conclude litigation as soon as reasonably and justly possible. But these rules have had no systemic implementation at the local docket or case level. Meanwhile, the practice of law fundamentally has shifted from an honorable culture of compliance where the rules established what was to be done and they were honored to a culture of enforcement. The rules matter only so long as the judge enforces them against you, which has increasingly required judicial time and valuable hearing time to be dedicated to corralling bad behavior and noncompliance, as opposed to deciding the fundamental issues that brought the case to court. The rules proposed here as a group are the overall solution within the case management structure directed at these problems. It's all a part, and I'll get to the phasing question in a moment, Chief. But, for example, by mandating disclosure up front and supplementation of discovery, hearing time, the vast amount of hearing time that was formerly tied up with discovery motions should become available to hear dispositive motions, which are now being filed with more frequency. While we also understand the fear of commenters that the sanctions aspects of this will be weaponized, the simple truth is we've appealed to professionalism and the better angels of our lawyers for more than 25 years, and it's not working. It's time to acknowledge the reality that there are strategic and financial incentives for abuse of the rules that we need to eliminate and which devour hearing time and as a result compromise access to justice, even when it comes down to just ignoring meet and confer requirements. Equally high volume practices, everybody that was here during foreclosures knows what I'm talking about, who ignore the rules, even in uncontested manners, have to be held to account as well. It's not everyone. The lawyers here are exemplary examples of the people who devote their time to making the practice and delivery of justice better. But just like reckless and inattentive and careless drivers on the freeway can snarl traffic for hours, the people who ignore the rules, or don't comply with the rules, or exploit the rules can snarl a docket, and it affects every case. Court case management became urgent when COVID-19 shuttered our courthouses. Jury trial dates, the sole driver of case progress. I mean, that's what you kept hearing everybody talk about so far. Trial dates, trial dates, trial dates. Why are we running our court system over an event that happens in 0.4% of cases? We are not continuing trials. We continue settlements. That's why trial dates are important. That's why continuances need a strong disfavor. Because the truth of the matter is the only time a case really should be continued is if there's some human tragedy. God forbid, somebody's got cancer, somebody's died, something terrible's happening. For a family leave reason, that's not a tragedy, that's a good thing. Or because somebody fundamentally doesn't have the evidence that they need that's important to their case, or the opportunity to discover it. All that should be taken care of if they follow the case management order. That should not be a game time decision at the time of trial that should necessitate a continuance. We proposed during COVID implementing statewide active court case management orders across the docket, and this is not guesswork. With all due respect to civil rules, there's 50 years of empiric evidence supporting case management. The initial report cited pilot projects from all over the country, including a pilot project in Miami in 2017 that involved almost 30,000 cases that demonstrated case management resulted in an 86% increase in cases being closed within time standards. This is not guesswork. This is not a bunch of, 10 people on a committee sitting around and navel gazing about what might make the system better. This is empirically proven. And to the point of civil rules and referring to civil rules, look, this is going to need work. This is going to need tweaking. But at the end of the day, to defer mass quantities of this to civil rules, they're not going to have any more empiric evidence in 2 months or 6 months than you have today.
So what should the priorities be? I mean, I understand that they're all trying to kind of work holistically, but...
Got it. I'm there.
Okay.
So if you asked me and said, Judge, pick or choose, who are your favorite children, right? I'm going to tell you, case management orders, those rules that are unobjected to, because the vast majority of what we proposed is unobjected to. Those rules that directly impact deadlines. So at issue, the bane of every trial judge's existence, continuance. I mean, I know the continuance is a debate, but the rules already say that it should be rare and for good cause. And lawyers walk in with agreed orders to continue. And so judges are signing them because it's agreed. What are the people behind those cases who have the problems thinking about that? They're thinking, why is my insurance case taking 5 years? Mandatory disclosure, duty to supplement, because we need those discoveries, issues to take off the pressure on hearing time. let me talk about where we are.
Could I ask a question about the discovery?
Yes, Justice.
Is there any concern with that discovery, mandatory discovery, that the plaintiff essentially has unlimited time to prepare their case before filing, except, statute of limitations or that, and then you give a defendant 45 days to get the exact same quantity of information? What was kind of the thought process behind that?
Well, so it's been in place in the federal system for a significant period of time. It's been in place in Arizona for going on like 20 years. And the truth of the matter is the defendant may not have everything that they need to know at the time, but let's at least give what is obvious and there so that we're not delaying the whole package, that the evidence that people need to fully understand the case is at least at an initial level on the table. You're never going to be able to get around the fact that plaintiffs pick the day they file and plaintiffs know the case before the defendant. What we can do is try and make sure that the evidence that both parties need is as available as possible.
And do you think it's clear in the rules that that initial discovery, there is flexibility there with what can be done? Because it doesn't seem that is the case. It seems like this is a sanctionable offense if you don't have all these documents in 45 days.
Well, it shouldn't be flexible in terms of what you have and what you can deliver. Because remember, we're looking at 18 months in a case, right? So we've got to get this case moving under the time standards. But where an item was not available or a defendant was not aware that a witness over here had something, then those are going to have to be addressed on a situational basis. You can't write a rule that's going to, if there's nothing else that's obvious from today's work, you can't write a rule that covers everything. But I think judges are going to have to use their common sense, but defendants are going to have to take this obligation seriously, and frankly have been in the long years that it's been in place in federal court and in other state courts across the country cited in the report.
Judge Bailey, what's the answer to my motion to arbitrate question?
That in the case law, you have to go in at the first instance and refuse to participate in the litigation and move to stay. So we've excluded arbitration enforcement under the rule. But if there's a question about arbitrability under the case law, that has to be brought up in the first instance. So theoretically, under UCR, the case would be put on inactive status. Once the arbitration decision was made, go to arbitration.
So let me make sure I understand. A party has an arbitration agreement. They file a motion to arbitrate and to stay.
Yeah.
Do they still have to participate in this?
Not as I read it, because that has to happen in the very early days of the case, like almost at the beginning, because the case law says once you participated in the litigation.
Yeah, you waive it. And
you waive. That might need some clarification. There would be a place to do that where we talk about proceedings to enforce arbitration. But I think the vision is you have to come in so early.
Do you agree that it should be exempted out of the requirement to do the case management? If there's a pending motion to arbitrate, they ought not to be required to participate.
Pending resolution of the motion to arbitrate, yes.
Okay.
Yeah, I think that makes sense. So we're at this strange inflection point. What we heard today is a reflection that all of us share, right? As a system, we have a deeply ingrained preference for the status quo. But if you told us in March of 2020 that we were going to put the whole court system on remote in basically 21 days, we would have asked what you're smoking. But we did it because the court system can change. And the changes that we're proposing here are essential. This is not the time, quite frankly, to defer for incremental changes, because we're losing public confidence. We're losing the trust of the people we serve. It is, without question, a very difficult time right now. Keeping these case management plan promises is really difficult. We had to implement while we still had the deep reservoir of aged cases that needed to be dealt with. The FCTC and clerks are working on getting a handle on needed technology. But here's the important thing I think we need to draw our attention to. The focus on most of the arguments today was on complex cases. Those are 5% of the docket. The vast majority of our docket is simple. The vast majority of our docket, if you include the county courts, one side is unrepresented. We have to craft a system that works better for everyone, including the lawyerless. It's been hard. I'm sure that you all have heard from judges across the state. You know, everybody's coming off 3 years of absolute trauma, trying to keep justice working during COVID. But we can't continue to cling to outdated business models and practices that no longer serve our citizens well. Let me just take a moment on resources, and I know I'm out. Can I keep going?
Yeah.
Okay, thanks. What we need is a gap analysis. So here's where we're at with the case maintenance system, right? So we went digital, we went on e-filing, and frankly, we didn't know what we didn't know, although everyone worked very hard at getting it right. So in those systems, there are a lot of things that we didn't need at the time because we were doing this procedure or that procedure that we've never taken advantage of, that we don't even know are there. By way of example, we're on Odyssey. And when we did the pilot project in Miami, I said, look, there's got to be some kind of automatic way to tickle up all these case management dates. Clerk, no. Finally, I got a meeting with Odyssey. It took 4 meetings. Finally, at the end of that meeting, I find out that there is a time standard, not our time standard function, what they call time standard, in Odyssey that will automatically calculate T+1, T+23, whatever you program, that's locally configurable. You don't have to pay Tyler a dime to use it. And it's embedded in Miami's dollar store version of Odyssey from 2014. There are aspects that can support this that we don't even know we have in the existing programs that we have. As I said, huge education question. We need to bring the bar in. We need to bring the portal in. We need to bring the FCCC in. We also need to redefine our workforce. Online scheduling is the way of the future. Almost all of our interactions where we make appointments are subject to online scheduling. The DMV uses online scheduling. But what we do in many parts of the state is we have RJAs on the phone with lawyers saying, well, I can't make it this day. Well, I can't make it this day. Okay, now we can make it. Well, she gave that date away. It is the most inefficient way to schedule. And it also prevents the parties from being aware what their options might be. We need to take our staff that does these red book, obsolete processes. We need to use our web pages to inform people of the practices and procedures of the courts as opposed to the phone. People should always be available, but they shouldn't be the first stop. And pivot this staff, our court staff, to more direct case support to keep the case moving. Because the other important aspect of this is judges need to be for judging. Judges shouldn't be doing file review to decide if everybody's served. Judges shouldn't be doing compliance monitoring. That is competently accomplished by those who are less trained and aren't as expensive as we are. We are the fulcrum. We are the highest and best resource in the judicial system. Judges need to be judging. And I want to be clear because I think there's a misunderstanding about this. Case management doesn't mean case management conferences. It can, but it means making a plan for a case that creates a schedule all the way through, that deadlines will be honored, that the court will enforce, and that reasonable access and hearing access can be provided at those critical times. And sometimes that means case management conferences, but not necessarily. Many judges across the state are under the impression, well, now I have to have a case management conference in every case. You don't. You just need to organize and sort your workload so you're giving your time and allowing access to those cases that need to see you when they need to see you. Right now, the way we prioritize our work is, who asked me last? What is the order you asked me in, and what do you want? That's not organizing a workflow. So, very briefly, I have two other points and then I'll step down. On behalf of all my colleagues, because I got tackled on this at the Circuit Judges Conference, trial courts are generalists. We make decisions in the moment. Some perceive that the appellate courts are perfectionists. There's a belief, supported in some opinions, that trial judges who enforce the rules and deadlines are going to be reversed. That's where the comments from this work group came that addressed the concerns that the Appellate Rules Committee raised. The ability to enforce the CMOs and the deadlines and have real consequences. Your witness, if you don't make them available for deposition, they're going to be excluded. If you don't list them, the evidence is not coming in. It's the whole basis for 1.460B. The intermediate appellate courts need to back up our trial judges. Enforcement is every judge's job at every level of the system, and the deadlines are going to have no credibility with the trial bench or the bar otherwise. With regard to the pretrial coordination court, lawsuits have gotten really complex. We've long used the consolidation rule 1.270 as a mechanism to combine cases, to limit cost and delay. Sometimes they're grouped by character with regard to like the asbestos cases. Some jurisdictions have tobacco divisions. But the complexity of the lawsuits we face today make the consolidation rule really not tailored to case manage at the level required by these significant issues. For example, Chinese drywall. Chinese drywall required significant coordination with the Chinese drywall MDL out of New Orleans. That was facilitated by putting those cases together. Did they technically meet the standard for consolidation? You know, every case was different. Every case had different drywall components. Some houses had multiple kinds of drywall, but clearly they all belonged together. More recently, FIU bridge collapse, Champlain Towers, demonstrated the benefits of combining these cases. These cases would have taken decades, and they were handled in Miami in under a year or two in both instances. Most of the time, we're able to do this by moral suasion and leaning on the parties, quite frankly. But where a party objects, it's unclear that the court, under this sort of general rubric of where justice and efficiency so require, really can put these cases together. And we believe that courts should have clear authority to put the cases together for case management. We chose the Texas model because many jurisdictions aren't aware of the complexity of process that involves. You could choose a simpler model, but we thought if we chose a simpler model, then people would say, what does this mean? We don't know how this works. None of it is mandatory. A jurisdiction doesn't need to set up a PCC if they don't think they need one. And cases can be assigned to a single judge within a division. I handled the FIU bridge cases while I had a full docket of other cases. It may, in some instances, for certain judges, require a workload adjustment. What it does allow is the cases to be assigned as opposed to just whoever's got the first filed case to a judge that has the experience to handle a case of those significant issues with case management experience. Tech, tracking relationships with motions, trying to make sure I don't miss anything. That is the golden ticket in case maintenance systems that's missing, and it's missing everywhere across the country. There is no effective way to tie a motion to a resolution or to identify what motions remain open in the existing case management systems, and we need to come down on the vendors to create that. It is what everyone needs. Right now, however, I will tell you that I think it's important that the docket index numbers, which is the way, the workaround on that, need to be applied at the portal level instead of at the local level so that we have a better ability to create workarounds until that vendor deliverable shows up. But that does not exist, and it makes things more cumbersome. There are workarounds. You can run reports. Okay, what motions to dismiss were filed this week? What motions to continue were filed this week? And that will allow you to find it, but it's, you know, it's the long division way of so doing.
Can I ask you, when you caution us against taking an incremental approach, what's in your mind when you say that? I mean, what what is it that you're telling us not to do? I mean, I know,
Yeah.
I mean, I know ideally maybe we would do everything at once. I know that doing nothing is an option, but what is it in between that you're cautioning against?
Well, I just want to make sure that everybody understands, like, this is not a gamble, right? That term was used. We brought this to you with lots of research and lots of backup that demonstrates most of it works. Where do I think it's a gamble? My colleagues are going to address motions and discovery because those are the hot button issues. Look, the motions rule is complicated. We had a lot of debate about it. I can write a motions rule for you that says, look, if you don't set your motion for hearing, it's deemed abandoned and cannot be refiled except for good cause. If you want to reply within 5 days, and the judge will either rule on it or the judge will rule on it if they want it in writing within X days. There was debate because we thought everybody would think that was unclear. So throughout the theme of this we wrote really detailed rules for people to push back against, which they did to make a better product. But the things that thwart case progress are motions that are dropped in the file and never set, especially motions for extension of time and motions to dismiss. They just drop them, don't set them. You would think the other party would set them, and they don't. So, and there's not a good technology way of alerting the court to the fact that there's this unresolved motions pending. So I think those are harder things. I think the clearest issue of of alteration of business process is going to be in the motion rule. But I'm going to have Judge Lee address that. And on continuances, I'll simply state, if people follow the continuance rule, the CMO, continuances should be unnecessary except when there's an emergency. A key witness is suddenly unavailable. A personal tragedy. But a case management order is a promise. It's a promise to the people who brought their issues to us to solve. And we shouldn't just be rolling these dates because it's not convenient for the lawyers, or the lawyers didn't bother to get the case ready, or the judge has someplace else to be. We need to treat them like they're the sacred trust they are, which is we promise people a resolution in civil court, and we need to deliver it as best we can within the time frame that makes the outcome while it still matters to folks.
Thank you very much.
Thank you.
May it please the court. Good afternoon, Justices. I'm Robert Lee, County Court Judge, Broward County. I'm the administrative judge for the county court, and I am in January starting my 26th year as a trial court judge. So I bring a lot of experience to some of these issues, not only from the county bench, but also for much of that time, my 4 different chief judges that I've been under have also put me in the sitting as an acting circuit judge in many cases. I presided over hundreds of jury trials during that time, and a lot of the things I'm talking about today are based on direct experience and also what I've learned through the wonderful work of the background studies. Just a couple of, it's hard not to come toward the end and have somewhat of a stream of consciousness presentation, but I wanted to address a few things. Justice Polston, the issue of arbitration now is even more pronounced with the issue of the right to demand appraisal. That's becoming, with all the hurricane cases we have, the thing that happens that stops the case. So we've already addressed that. We have that, a state provision in place, and it stays the operation for a certain period of time. So we've adjusted to that particular issue, and unfortunately, because of the 2 most recent storms, we're going to continue to have those issues in the trial courts. But I believe those are encompassed within what we've proposed for you folks today. I do want to note that as much as we talk about these aspirations, there have been many judges trying to do these things over the years. We know Michael McHugh in the 20th Judicial Circuit put a great DCM system into place. We've heard from the 13th Circuit, the 11th Circuit, my circuit had it in place before COVID. And one of the reasons I am a proponent for keeping in that subdivision F in 1.200 in the case management rule is for those circuits who have demonstrated that they already have a resolution to this issue, they should be allowed to keep that system in place. There are certain times when you need a different type of order, depending if it's foreclosure, for instance, consumer debt, a certain type of order that's applicable, and most of the time what we're talking about now is insurance cases in the state of Florida. Just so that you understand the volume, and I don't want to make a lot of statistics, but for 2021, there were almost 85,000 insurance cases filed in Broward County Court. That same year, there were 16,000 filed in Circuit Civil Court for a total of just over 100,000 cases, all going into the case management pool. It's critical that those cases be on some track that we are able to monitor them. And I will note, starting in January, more of those will come over to county court when our jurisdiction goes up to $50,000. So there's a tremendous need, and I don't think anyone's really debating the need for strong case management here. I do want to address, and I picked the short end of the stick by getting to talk about motions and hearings with you folks today. And I do want to echo a lot of what Judge Bailey said. These particular rule proposals were negotiated over months and months of a lot of discussion and how do we do things and what would work and anticipating what glitches might be. But we do know for a fact that more than 50% of all motions on a civil docket settle, resolve before the hearing. We do know that. We've traced that, we know it, and so what we do know is that how do we get attorneys to do whatever they're doing the day before hearing, do it some earlier time? So the first suggestion in the rule is they have to have a discussion about the motion before they file it. The idea is if they have a discussion about the motion before they file it, the odds are a great many of these motions will be submitted agreed orders rather than just dropped in the file and forgotten. That is a significant problem. We know it now, certainly with case management, because as we're doing our case management and we're hitting certain dates, whether it's 120 days to make sure there's been service of process, you see them languishing. Motions to dismiss filed 40, sometimes 90 days prior, and no one brings it to the court's attention that there's a motion to dismiss that's been filed. What this rule purports to do is require the attorneys, and I will say it's not in every case. There's a whole swath of motions that are exempted from it. Directed verdict, of course, default, summary judgment, fees and costs, new trial hearing, remitted or added or motions for relief under 1540 and motions for expedited resolution are all exempted from that process. So we're really talking about discovery motions, motions to amend the pleadings, motions for reconsideration, and sanctions motions. Those are the motions we're really talking about that attorneys need to talk about, because most of the time for those types of motions there can be some sort of resolution. That should, number one, open up hearing time there. Okay. So then, number two, if they can't reach a resolution, why shouldn't they notify whatever system we put in place, the court, to say, we weren't able to reach a resolution on this case, we would like a hearing. They have to tell the judge one of the three: either we want a hearing, we don't want a hearing, and we want you to rule judge, or we want, or the other two choices are we want either one of those options with briefing. The judge can say, set it for hearing. Justice Labarga, if someone said they had an in-camera they wanted, I would, just hearing the word in-camera, I would say set it for hearing. But if it's a rudimentary, same day in and day out, I've even given my judicial assistant of the most common motions that come in that I know I don't need to see. I just know by what they're saying they are whether I need a hearing or not. And some of these, motions for extension of time, motion to compel, something along that line, the judge may not need to say anything other than tell them to set it on motion calendar. I don't need to see anything more. I'm a very strict case manager. Everyone knows that about me. I do not allow anything on my docket unless I know what's on there. I have been doing that for over a decade. So when I do that, I've developed, just knowing through experience, certain things that should not be on a docket. I know when I compare myself to some of my colleagues, I have double the availability of hearing time. Why? Because I don't let attorneys just set anything on the docket. And I think that's one of the things we're looking at, a report you're going to get from us in February, Justice Muniz, on the work group on judicial practices. That's an issue that this court has asked us to look at, is how do we increase hearing time availability? So getting a lot of these motions resolved up front and not letting them languish, whether it's they have to notify us, and if they don't, the rules in there that they're deemed abandoned after a certain period of time. Why should we have to worry as trial court judges whether there's been a waiver, an intentional, because we have to demonstrate that they intentionally relinquished the right to have that matter heard. It should be abandoned after a certain period of time so that the trial court judges of the state, this, in my view, saves judges time. There's lots of suggestion this is going to increase judges' time. In my view, a lot of this saves judges' time. As far as judicial discretion, when I read the motion practice proposal, I see 7 times in there it refers to a judge may or may not do something. The 7 times it refers to the judge's discretion. In the hearing, there are 6 times it refers to the exercise of the judge's discretion. So the judge still wields tremendous judicial discretion in this particular case, under this particular proposal. We really are struggling here, and as we've gone through this, to meet 2 things: having motions resolved, but also having hearing time available and getting trials done. And one of the things that we've learned through the studies is that merely setting a trial date alone is not going to resolve anything, because the attorneys will inevitably wait, and we know this through experience, until the last minute. Whether we have case management conferences or not, before I have a pretrial conference for the jury trial, I always make sure that they have filed their joint pretrial stipulation. It's required in our case management order, and 90% of the time the attorneys have not. So you bring them in. Now you set a case management conference within fairly quick. You bring them in, ask them why. They said, oh, they forgot about it. They were too busy. COVID, staffing, they go down the whole litany. But there has been a culture developed over the past, since I've been a judge, that court orders are suggestions and they're recommendations. And in my view, it ties in with the sanction order. It is simply too hard at a hearing like that to find that someone's acting in bad faith or willfully disregarding your order. It should be, frankly, easier to hold an attorney accountable when they're not complying with an order. Every trial court judge I know has been reversed on appeal on this issue because they think that there's a reason they should impose a sanction, and yet they find out because there's not really a finding of willfulness, it's going to be reversed. As to the issue of the discovery sanction rule is a little bit different because by rule, it makes it a shall. It doesn't matter whether it's like if it happened, it happens. Like you get a traffic ticket, it doesn't matter if you meant to do it or not. If you were driving 75 and you didn't know it, you still get the ticket. And it's the same with the sanction rule. We're not talking about just discovery sanctions. We're talking about sanctions for people who don't file their joint pretrials, who don't show up for hearings. This is actually becoming epidemic even with Zoom. Attorneys think, oh, I didn't show up, oh, I forgot to turn it on. And you have the same attorneys 3, 4, 5 times that do it. You finally call them in for an in-person, and then they say, well, under the rules, I have the right to appear by Zoom because it's less than 15 minutes. So I have the right to, so I say, well, it's evidentiary, so now you have to come in person. So that's what our focus was here. These are real problems that we're trying to resolve. I do recognize it is a complicated procedure, but the bottom line is, as far as the scheduling, and I'll echo what Judge Bailey said, we know now about a third of the judges in the state of Florida have access to online scheduling. Not all of them use it, but they have access to it. That means 70% trial court judges do not. It has made my life and my colleagues' lives so much easier as judges to just have the attorneys know, once you tell them, set it for 15 minutes. But inevitably, you're going to get the email, your J, the other side won't agree. So you're going to have occasionally that issue. I think one of the judges in David Miller, I think in Miami, he calls it the frustrated lawyer docket. He actually sets a frustrated lawyer docket where he opens a special time, sometimes 7:30 in the morning, just to hear certain cases so you can get folks in. So yes, I do agree that those are things, although the people that use old-fashioned scheduling, they like that. It's mainly because they're used to it. But my chief judge in my circuit mandated that we all use it, and once he mandated it, we used it, and guess what? It's working wonderfully for all of us, and we're lucky enough to have the technology. I don't know if you have any specific questions for me on any of these. I do note that I just want to briefly echo, since the mediation rule was brought up, as the county court judge on the work group, we feel strongly that there needs to be some tweaking to that mediation rule to help judges in small claims. Mediation in small claims is really being thwarted because of the requirement that each mediator has to give an orientation session one at a time, privately, rather than en masse. And the truth is, as we've said in our report, if you can do it in a criminal division, in an arraignment docket, you can run a video that says these are your rights, et cetera, et cetera. I don't understand why. The orientation session is a creation of rule. And I don't understand why, to assist the judges in small claims, and those are hundreds of thousands of cases a year, to be able to facilitate. We figured out if it saves an hour a day per judge that handles them, that's still an hour a day the judge could be doing something else.
So what would your priority list be?
I agree that we need to have a case management order in place. I believe it should, with the caveat that it retain the option for the local circuits, as long as they have included what's in the rule to have their own dictated, because the current rule allows the attorneys to dictate. Most of the circuits have one that the circuits have said this is what the options are, and you have to comply. So that would be number one. I do believe that, in my view, the sanction rule needs to be addressed. I think the trial court judges are very frustrated at the difficulty in sanctioning lawyers for noncompliance with rules and court orders. And actually, those are my top two. I don't know if the mandatory disclosures, and I'll just say that issue on the mandatory disclosures, Justice Grossman, because I know you mentioned it. That rule was drafted so that the party has to disclose what they know at the time. So it shouldn't be that they're not required to go out and investigate, but they are required to supplement once they find out.
Didn't you modify it to for the disclosure of categories, not just documents? Initially,
right.
It was documents, right?
Right.
But then you modified it.
If you had, I think we left insurance policy there, that you actually had to give the policy. But if you can just list the categories of documents rather than going and getting them.
Thanks, and thank you for all your hard
so
work on the JMC in general. We appreciate it.
May it please the court. Tom Edwards from Edwards and Ragatz on behalf of the task force, and I'm here to discuss discovery and other issues with you today. we have revised what we originally proposed as it relates to discovery, and we modified the discovery rules to largely track what is done in federal court with the disclosures and the supplementation. And there are a few minor differences, but you will see that we had written one set of rules, and when we got the comments, we came back and we made some meaningful changes, having listened to what our colleagues had to say. And we made the decision that by adopting largely what is in the federal rules as far as disclosures, supplementation, et cetera, there is a body of case law that we will be able to look at and a body of experience that is broad-based. So we feel that the initial disclosures and the duty to continually update your discovery are both very important components of this if we're going to keep cases on track and moving.
Could you address the proportionality? Because, I mean,
yes, sir.
You really didn't exactly go there, although there's some language that sounds kind of like that.
Yes, sir.
So I guess my question is, if you've got language that sounds kind of like that, why not just use the language that's in the federal rule where we've got the body of case law and all that?
Federal Rule 26B a few years ago was changed to adopt proportionality language, and there has been a tremendous increase in litigation over proportionality, even though when you go back and you read commentary on it from law review articles and from judges and magistrates that have published on this, all of those rule components were already in the rules. And what they said is, by making this a front and center change, we ended up engendering lots of litigation over proportionality that was already being handled effectively before. If you look at our report, the last final report, page 20, footnote 51, we cite to a couple of cases that discuss those issues. And what you end up finding is that by putting proportionality front and center, it became a hot button fight issue, and it is now causing a lot of fights that in our court system are going to delay cases. And the reason I say that is the resource issue that you've already heard a good bit about. In federal court, it works very, very differently than it does in state court. When I file a motion to compel in federal court because the other side says, or the other side files a motion and says, no, that's not proportional, you're asking for too much, we object to it, and we're moving for protective order. We have a magistrate that typically within 10 days to 2 weeks has contacted everybody and set a hearing on it. And they don't wait for us to set a hearing. We don't go through Rule 1.161 to go back and forth trying to get a hearing. A magistrate calls us and says, you're going to be in my courtroom in 2 weeks and we're going to resolve this. And we do not have those resources in the state court system. That magistrate has a couple of law clerks and they are on it, and it gets dealt with very efficiently and very quickly. Our group looked at this and debated proportionality. And the reality is, when you read some of the cases that are cited in our footnote, what you're going to find is the commentators, one of them, a magistrate's decision, talks about the fact that all of the components of proportionality have been in the rules of civil procedure and in our rules of civil procedure for years, and they all relate to motions for protective order. And so what you will see is we've already got proportionality and have had it for years as it relates to ESI. If you look at our existing ESI rule, proportionality is in there. If you look at the way in which motions for protective orders are considered in our current rules, that is a proportionality analysis, and we incorporated that analytical standard A4, which I think one of you referenced earlier today, as one of the objectives to meet in the case management rule. When you look at the objectives, I think it's 10 objectives, and we included language that is typically used by a judge in evaluating a motion for protective order. And so what we said is, if you change the rule, you're probably going to do just what has happened in federal court. We're going to have a whole bunch of discrete proportionality fights. If we continue under the same wording, the resources are already there for our judges to deal with this under the same analytical standard. So that's our analysis. We don't want to slow cases down. Your instructions to us were to keep them moving and hopefully improve the movement of these cases, and we think that's a better way to do it at this point. And if we're going to bring proportionality in, let's do it at some point in the future, particularly with all the other things we're talking about. Any other questions on that issue? Okay. The discovery is in the efficient movement of discovery is critical to what you've heard from a number of different people who've talked here today for us to accomplish, and that is resolution of most of the cases that go through the system. What you will see is there is a comment to proposed rule 1.279 on page 35 of our final report, which addresses the Dodson v. Purcell case and a handful of additional cases that talks about the importance of proper discovery exchange and how crucial that is to the entire process of the system. When lawyers have equal access to information about the strengths and weaknesses of cases, most cases end up going away if lawyers are doing their job and encouraging their clients to pay attention to what both sides of the case are. And so having a proper exchange of discovery is a core component of being able to get these cases to move through the system appropriately. And what we have found is over recent years, there is a great deal of discovery abuse, and people do not get discovery until you're well into the case. And if that pattern continues, case management orders are not going to be effective because they're going to end up crashing, because if we have to have motions to compel Florida Supreme Court standard interrogatories, which I will tell you I have to do on a regular basis. To get answers to Florida Supreme Court interrogatories, I have to go have a hearing, and the day before the hearing, then sometimes I get it and sometimes I still have to go get an order. If I have to go through a 4 to 5 month process to get in front of a judge, and I fight with the lawyer over how long the hearing is going to take, what they have available. It's very common for me to be told, oh, I've got nothing for 3 to 4 months. And that's why we set up this motion system that no one likes. And I will be the very first person to tell you that I think Rule 1.161 is cumbersome. I'm worried about it, but we don't have a system that compels people to work with each other on getting motions set. And so when I call and say I need a 30-minute motion to compel my discovery because you won't answer it, I'm then told, well, I don't have anything for 3 to 4 months, and I think it's going to take an hour and a half, not 30 minutes. And now we're in a fight, and we're back and forth with the JA for weeks before we get a hearing set, and usually the hearing's then set a number of months out. And now if we're on an 18-month track, and I have to go through, let's just say, 2 motion hearings, and each of them take 3 to 5 months to get set, we're getting close to a year into a case before I get my discovery. And now either I've done a bunch of depositions without discovery I needed, and may have to go redo them, or the case management order is going to crash.
It's like using the fire alarm to tell when the cookies are done.
Yes, sir. And so when you hear people saying that's why this is all integrated, that's what we're talking about. And the scenario I just painted for you is happening every day in our court system. And I have to say, this isn't happening in the everyday run-of-the-mill lower-end case. There are many, many cases that go through our system that don't deal with these things. But when you talk about the litigation that you all could pick the ones by looking at the rating system where you evaluate where judges' time gets spent on different case types. You know the ones where these kinds of things are happening. And that's really the ones that these rules become most important for. So the discovery rules that we have adopted largely track the federal rule. There's a good body of case law on that, on early disclosure of basic discovery and a continuing responsibility to supplement. I fully agree and support the doing away with the at issue rule and having case management from the very beginning, because if we get those deadlines, now we've got more teeth. When I go in and say, Judge, they've refused to answer all this stuff, and half of what I've just asked you to compel are Supreme Court interrogatories, and now they've messed up our case management order. I'm not sure we can stay on it. That's why you ought to be awarding sanctions, and that may give the judges cover, because aspects of the sanctions motion and continuous motion make me nervous too. But if we don't have some type of complete program here, we're going to have trouble keeping the case management order enforced. I will tell you that we have seen that Many in the defense bar are objecting to having some type of time standard associated with comparative fault defenses. And you've just heard a presentation on that. Again, this is going to adversely impact managing the case management order, because let me tell you in the real world what is happening. If I were to go in and try to amend my complaint in a personal injury case or in a big business litigation case, after expert disclosures and sometime in the month or so before our pretrial conference, a judge is going to look at me and say, number one, are you crazy? And if you're not crazy, tell me what has happened that's a significant event in this case that has caused you to wait to amend your complaint until the eve of trial. And if you don't have something that's really, really good, I'm not letting you do this amendment. That's the standard I face in virtually every case. When it comes to Fabre, the statute, the comparative fault statute says you're supposed to amend under the rules of civil procedure or you're not supposed to amend. But the default position that has now happened for many years, and you all rarely ever see it for this reason. The defense comes in sometime in the time frame of expert depositions in the time frame of 1 to 2 months before the pretrial conference and says, we've now got 5, 3, however many new defendants we want to add in a motion to amend our defenses to raise comparative fault defenses. And for the first time, they name who they are and what they did wrong. And this is after virtually all of your fact discovery is done and you're now in the midst of experts. And when we go in front of the trial judge, I have heard probably 100 times over the last decade and a half, Mr. Edwards, if I exclude this, there's a real chance we're going to try this case a second time. And if I grant this, I'm potentially causing you some prejudice. So you make a decision right now. I'll give you a continuance if you want it. And if you don't want it, then we're going to trial and they're going to be able to have these amendments here at the last minute. And that is happening every day in our court system. And you don't see it because 9 times out of 10, unless I've got an elderly client that may die or some other problem, I'm going to end up having to say, well, I've got to go get some new experts. I've got to redo some of the discovery that's already been done. If they're going to blame these people, I've got more work I've got to do and we need a continuance. So if we don't have some kind of time standard where you all either tell us who you're going to blame in this case on a reasonable period of time after you have knew or should have known of this defense, if that time standard isn't going to be there, we're going to continue to see this happening in the last couple of months of the life of the case. And we're going to continue to have case management orders blown up because the trial judges, if they're going to be fair, is going to have to look at us and say, well, it's on your plate now. Do you want to continuance or not? And that's why we recommended that with Fabre, they need to disclose if they knew or should have known, or if they're going to disclose late, come in and show that just as I would have to, there's some new piece of evidence, there's some new change, and there's some reason why they're going to name it late.
Mr. Edwards, on the case management, Mr. Webster brought up on behalf of some law firms in the Fourth Circuit issues about cases involving mass torts.
Yes, sir.
And some concern over the case management aspect of that. Could you address that?
I think he was talking about the pretrial coordination as opposed to the case management. Most of them are under case management, but this is the pretrial coordination where you have consolidated decisions made by you amass issues in certain classes of cases and have issues decided by one or more judges en masse for all the cases. And that's not something I really worked much on.
No, go ahead. That's fine.
Okay. On the issue of discovery sanctions, and I will tell you we consolidated our sanctions rule or attempted to consolidate it. The sanctions rule that we currently have in the rule book is almost identical to the sanctions rule that is in the federal rules. I think they are either identical or almost verbatim identical. But there is a very different culture in federal court versus state court. And I can tell you that, but I would also have to say when Peter Webster was a judge in Jacksonville, I tried a couple of cases when I was a young lawyer in front of him, and he handled his cases like federal court. He did case management even back then before many state judges knew about it. And if you went in and you were fighting over stuff that was silly discovery stuff, you were usually told, get out of my courtroom, I'm handling my next hearing, you two have 5 minutes to go agree to this or come back in, I'll resolve it, and then you're both getting sanctioned. That is very unusual in our state court system, and I don't know what the solution is. I worry about the way we've drafted that rule. I am a member of this group, and I support the overall presentation of what we've given you, but I also worry that we shouldn't sanction good lawyers for fighting over things, as one of you asked earlier, that good lawyers fight about, particularly when you could go to 3 different judges and get 3 slightly different rulings on things. But we have to have a culture change on continuances, and we have to have a culture change on sanctions, because right now things are not working and people know it. Having the case management rule may well start forcing things through the system in a slightly different way, and that may help those problems without some of the significant changes we've changed, which also depart from the federal rules. But things are not working right now in those 2 areas, the continuances and sanctions. So why don't I pause at this point and see if there's some additional questions.
So you've said there's 3 or 4 different things that you're worried or concerned about. What should we be most worried about if we were to do what the work
I worry about the sanction standards, because as I said, but I will also tell you, Judge or Justice, that the rule on discovery says shall already. There are 3 exceptions under that rule, and there are identical exceptions under the federal rule. And the federal case law and the state case law has developed that there is some protection if you're doing your job right. And we need to ensure that good lawyers don't get sanctioned for simply because they lost a hearing. And because there are lots of consequences to that. You can lose your malpractice coverage. You will not get in lots of reputable and important organizations. There are lots of consequences to having a sanction. You probably can't get board certified. The other one is the continuance rule. We have set a very, very stringent standard for continuances, and some commentators feel there's some inconsistencies in some aspect of the rule. Justice Coriel, your suggestion that there should be one free continuance.
Not free.
Good.
One continuance under the current rule.
There need to be standards, and because. And as was said earlier, I believe by Ms. Luca, it should be that they should be rare, and there should be very good cause shown. And once it's been continued once, it should be even tougher to get a second continuance. So sanctions and continuance and having an appropriate method for timely getting motion hearings are a crucial part of this. And I think our rule is cumbersome. I worry about it. I know Judge Bailey and others advocate an automatic system online, and I think if that works, it's wonderful, but there has to be a safeguard. There has to be a backup system for when I get the lawyer on the other side that says, oh no, you think it's 30 minutes, I want an hour and a half or 2 hours, and by the way, I can't be available for 3 or 4 months. I've got to have some place I can go to get help with that. And if all I've got is the automated system, that doesn't solve that problem. So I will tell you, I think I've heard you ask others for priorities. I think the case management rule is very important, and there might be 1 or 2 minor tweaks that have been touched on here today that could improve it. I think the discovery rule, which we have without the proportionality issue, we have largely made the discovery rule identical to the federal rule for early disclosure and supplementation. Doing away with the ad issue, and then the other pieces I think I've spoken to as to where I have any concerns.
Thank you. Judge Morris, we're at the end here. You've listened to everything, your colleagues, the comments. Could you take a couple of minutes just to kind of sum up and give us your thoughts?
I don't have a whole lot to add. I just, this has been a rich dialogue today, and it's been very fruitful, and I appreciate listening to everything that I've heard. I just remember when we started this project, Justice Muniz, Chief Justice Muniz, you said you want our civil justice system to be the envy of the nation. I remember that because that stuck in my head. And that has been our effort. We've been very aggressive in what we have done, trying to achieve that very lofty goal. And I don't know that we did it or not, but we tried. I mean, that was our effort to sort of live up to your desire. We've talked about this change and this monumental change, this sea change. It certainly is that. Change is very unsettling. Sweeping change like this one can be unnerving. This isn't lost on us, we know that, but we're all in this together, and I think this morning's hearings showed that. What we have done is not a perfect product. You heard commentators who had very good suggestions. It could be tweaked a little more.
So to the extent that there would be a need for further revision or for prioritization or something like that, do you have any suggestions in terms of mechanics as to how to, and I'm asking you publicly because the way this case stuff works,
yeah,
we can't.
I would think it would go one of two places, either back to us or to the Civil Rules Committee. But wherever it goes, it should go with a deadline. And it should go with a deadline and some directions that we think maybe you should work on the motion rule a little more, or we think maybe you should, work on the discovery rule a little more. In other words, some targeted focus with a deadline, whether it goes to us or whether it goes, keep going, right there, them, that would be your call.
Okay. Well, thanks again for all your work to you guys, and there's other members on the work group. I saw some of them out there in the audience, and thank you very much to all the commenters. I think this has been hugely helpful for the court, and we appreciate it. We're adjourned.
All right.